So Representative Wallner, Pat Long is coming in today for Sharon, and I think they may be tied up in executive session. Do you have any issue with us getting started without Pat here? Okay. All right. Oh, good. Sorry, I don't know why I couldn't forward it. I tried.
Did you interview some more prisoners?
Yes, I did, and I get 2 more, not next week.
I handed it to him. He goes out and interviews the people that were involved who are now in prison.
Are you ready?
I was telling Ken that
We're going to start on 103.
I'll call it 1 o'clock, and 1 o'clock I'm going to convene this session on House Bill 103. We've had some amendments to it. I'll start by asking Mr. Ripple if the very last minute changes I was asking for were able to be accommodated by OLS.
Not in the form of a formal amendment just yet, although they are working on it. But we have the amendment that was drafted yesterday along with your proposed changes.
Okay. Okay.
Thank you.
Okay, so I'll talk a little bit about the context of what's happened since our last hearing, and then we'll bring the department forward. We'll probably just have a few questions just to close things out. But so we're really close. I ended up talking to the Senate about Senate Bill 422, and by saying the Senate, I actually mean 5 different senators to include the prime sponsor. And I explained to the prime sponsor that, in my perception, 422 and 103 were extremely similar to one another, but that 103 had reined back some of what 422 wanted in terms of our asking for patients to pay a copay when they were able to, and also to carve out the particular patient population demographics that would be subject to receiving dentures. The 422, the Senate version, was open to every beneficiary, and they had no copays. We liked their $1,500 annual cap, so we took it in our amendment, and we also liked their use of the Centene funds that we used in our version. The distinction in the Centene settlement funds and our version is that Mr. Ripple, would you remind me of the term for the $2.4 million that there was something about a risk corridor?
Right, there was $2.4 million for a risk corridor settlement, which the department would be able to explain in better detail than I can, but it was basically for overpayments that the federal government made because of flawed pricing methodology on the part of Centene that the state now owes back to the federal government.
Okay, so thank you for that. So since we had no hearings in the House on the risk corridor issue, we took that, we excised that from 103, and we reduced the amount of the settlement we would lay claim to by the $2.4 million. That way the risk corridor issue can stand on its own, and maybe what could happen is SB 422 would get amended down to where it was just a risk corridor bill, potentially. So those discussions were held with the prime sponsor and several co-sponsors, and I think generally I could expect the Senate to support HB 103. We'll see how that all plays out, but that would be my prognostication. As I was going through the amendment that Mr. Ripple had prepared on our behalf, the Edwards-Erf Amendment 2022-086 Hotel, I reread it, and what seemed to me to be missing that I had never really noticed before was there was no discussion in the statement of purpose about the importance and the primacy of individual responsibility to take care of their own oral health. So Mr. Ripple has gone down to OLS very late in the game because I was very late in the process. And for example, on page 1, line 8, we would add that in addition, the general court recognizes that personal responsibility is an essential component of any strategy to improve individuals' oral health. Without that statement, you could almost imply that it's the state's responsibility to take care of people's oral health without acknowledging that first and foremost, it's an individual responsibility. So I don't think this is a controversial addition. I just think that it tells a fuller story. And for anyone wanting to compare 422 and 108, this sentence could help them understand that the House version is placing relatively slightly more emphasis on the personal responsibility of individuals to care for their own oral health. There were a couple other minor edits, like on page 1, line 19. I'll give you a second to find it. We added in the existing list of goals, the goal of fostering individual behaviors that promote good oral health. Also on page 1, line 26 and 27, we added to the list of states' needs patient education. On page 2, line 4, we, again, similar, added patient education. And I think this actually just completes and rounds the circle, because we already had included in the specific deliverables of the contractors the fact that they needed to, where is it? That on line 26 of page 2, it says that they were to conduct behavior management and smoking cessation counseling. So we had already anticipated the need for patient education to be in it. This just makes sure that the framework supports the specific thing that we asked for. So I don't think those are controversial additions. They're just not in the amendment that we have before us. Is there any discussion on that? I'm hoping everyone at least has Mr. Ripple's change document and we're able to follow along. Is there any discussion by the committee? Because what I'd like to do is get through HB 103 and then recess us, because we're going to have a long session on HB 1677, and hope that OLS can complete the work, and then we can just vote on the latest amendment this afternoon. That's what I'm thinking we'll do. Representative Rogers, Representative Wallner, do you have any? Yes, Representative Wallner, and you need the mic.
Thank you. I just wondered, I assume that you have run this all by Mr. Littman to be sure that this works for the department, and in his contracting it works.
So I'm going to go with a partial yes on that, and then I'll explain. The partial yes is that he's seen the amendment, and so has Dr. Finney, seen the amendment 0868 Hotel, and I've gotten word through, I think, Mr. Shapiro, that you got, or Representative Shapiro, that you guys were good with that. The new thing that's a little bit of a surprise to you is the new language I had added about including personal responsibility for your oral health. And as I was reading it, I was watching, your body language seemed to be saying yes, but I don't want to assume too much. So do you want to come up to and introduce yourself?
Good afternoon. For the record, Henry Lippman, Medicaid Director.
Good afternoon, Sarah Finney, Medicaid Dental Director.
Thank you. Did Mr. Ripple hand you a copy of my changes here, these words?
He did.
I know it's a little quick, but on its surface, do you have any issue with adding this terminology?
None. I think it just solidifies, as you explained, all the way through what the intent is, and I think we can work with it for sure.
Do you follow up? No?
Nope, thank you.
Okay, thank you. Are there any other questions? I just want to keep it focused for now on the additional supplement I would add to the language on individual responsibility. Okay, so seeing none, we can get into the amendment itself, and I think we did a pretty good review, and that what the changes are from last session is the addition of the comments that we made during that session. Like we included the Centene settlement, for example. We included the $1,500 ceiling, right? Pardon me?
The $1,500 was already in there.
Oh,
All that
okay.
you added was the Centene, you changed the appropriation part to reference the Centene settlement rather than just an absolute dollar amount.
Okay,
that's all you
so
changed.
thank you for that. So I want to go to page 3, lines 6 through 8, and I want to touch on something that Dr. Finney shared with us in testimony last week. Last week, you mentioned a specific number. You said that anyone that was over 100% poverty level would pay 10% of the bill. All right. So just as I'm reading lines 6 through 8, I don't see 10% called out as a number, and so I would just want to hear you explain how this language means 10%.
Can I take? In line 6, you have to the maximum extent allowed under CMS guidelines, and that is currently the maximum allowed, and obviously if we have to follow the statute there, we would, if it increased or decreased, we would have to follow that, but it's been consistent for a long time. It hasn't changed, and I'm not aware of any changes in the offing.
All right, I assume that, but I didn't want to assume it. So then the other thing, I had a question from the other chamber about annual renewals, and I believe Dr. Finney said this in testimony last week, but because I was asked by a senator, I just want to double validate this. What the process would be, as I understand it, is that incomes would be certified annually, and that we wouldn't go back for recertification until the next year. So that if there were a change of incomes in mid-season, they would continue to pay out under their previous enrolled amount. Is that true?
If I could,
Partially, you go ahead, because you have.
if I could take that one, if it's okay. So individuals are supposed to report changes in circumstance, which would include income. So, for example, someone could, who wasn't employed might get a job, and that would change their income and potentially their eligibility. The other way around could also happen. Someone could lose a job and their income would go down. So it is generally and most frequently an annual redetermination, but there can be changes for changes in circumstance, and it could be someone had a medical condition that changed their circumstance, so they went into a different eligibility group. They could age like someone who was a child who's now aging into the adult you know, in an in-between period, that could change as well.
Okay, so you actually cleared up my misthinking on this. But for the people at the reception desk who are trying to collect the money, the answer remains the same to them. When the patient comes in to visit, they check the system to check the status and then act according to the status in the system.
Yes,
So all of the changes in, their Medicaid enrollment status are, basically transparent to the providers. It's just what the department does in background.
yes.
Okay, all right. So that addresses the additional questions that I had on the bill. Are there any other questions? Representative Rogers, Representative Wallner, you okay? Representative Weiler, Representative Erf, Representative Bean, anything? Okay, so what I think we've achieved is I think we've achieved clarity on the amendment to HB 103, Amendment 0868 Hotel, and that I don't see any opposition to modifying this language so that it reflects that personal responsibility is also a key aspect of the program. Is there any opposition to that, from the department, from anyone in the committee? Okay, so with that, I think we'll put HB 103 into recess, believing that it's possible OLS can deliver a fresh amendment before we finish HB 1677 this afternoon. So we're on recess for HB 103.
Oh, that's always better if we can, but,
I'm clear, I can. If
okay.
Okay, so the status for anyone in the room who is curious is the next thing we're going to do is HB 1677. That's in the House calendar at 2 o'clock, so we can't start before 2 o'clock. So the committee is really on recess till 2 o'clock until we hit 1677, have Division 1 join us. It's 2:00, and so I'm going to call this hearing into session. This is the hearing on HB 1677 FN. For those of you who are following along, we are primarily referring to the Umberger Amendment. That's 2022-80891 Hotel. Keep that distinguished in your notes. You may want to write big on that, that's the official version. And the reason I point that out is because the Victims Council has also submitted I'll call it a red line with their recommended changes. And so they look similar. You'll want to keep them distinct. The other thing that the Victims Council has provided us is a summary of changes required by the Victims Council. That's a bullet list of 10 items. We're going to walk through that. In discussion, I think there may be 4 additional items beyond the 10 brought up by the council that we're also going to talk about. So what could very likely happen, given the number of recommended changes before us, and given that the Finance Committee needs to know our position on the 8th of March, I think we're going to end up going through everything we can today, come into as much agreement as we can today, and then recess until Thursday at 2 p.m. The reason we're starting at 2 p.m. instead of earlier that day is our chairwoman has a medical appointment, and we wanted to make sure she gets to that and can come join us before we wrap up. So that's kind of my overview of where we're at and what I think we're going to do today. It's going to be walking through the list of 10 items plus 4, and we're going to have a show of hands. One moment. We're going to end up having a show of hands at each of these bullet points just to get a sense of the committee on where we're at, because we need to give guidance on what changes to incorporate and which ones we won't. So Representative Rogers, you have a question?
Thursday the 3rd, you want to meet at 2 o'clock, you said?
Yes, ma'am.
Okay, and how long, do you have an idea of how long you think we'll be here then?
Well, I think that we could finish in 90 minutes or less. And the
Okay.
reason I think that is because we'll have done the discussion and straw votes today, and then come Thursday at the 3rd at 2 p.m. At that point, we're just validating that that OLS has crafted a version that we can pass to the Finance Committee. So I don't see a lot of discussion on Thursday afternoon.
Thank you.
Okay, so before, yes, ma'am.
Yeah, if we
Okay, yeah,
could,
find
I
out
would like
what's
to
coming
have
up.
the changes that Kevin and Mike have been working on that deal with finance, to let them go through those before we start on this, if that's okay, or whenever you want to do it. But we did make some financial changes to the bill. Not in the 100 million, but in how we're getting the money and so on.
Okay, the reason I look confused is because I'm just a little confused. I was prepared to go through the 10 items presented by the Victims Council plus the 4 items we talked about in caucus.
Right.
Okay, is there another stack of things that we need to talk about?
Just a couple of things.
Okay, could you tell me again what they are? That Mr. Ripple had some financial changes, and are those reflected in this document that we have before us, the Umberger Amendment 0891? Are they in there, or are they
Yes,
elsewhere?
They're in there.
All right. So, Mr. Ripple, do you want to go ahead and take center stage, or Mike? Either of one of you, Mr. Hoffman?
Yes, I will. I'm Mike Hoffman, by the way. I work with the Legislative Budget Assistant. The amendment before you, number 891H, incorporates all the changes in the last version that the AG presented on Thursday, plus 3 other items. The first item is that the Attorney General maintains control of the fund. The second item provides language for reimbursement to other agencies for costs that are incurred. And the third item is that the appropriation, instead of coming from the general fund, would come from the rainy day fund. So on page 1, in the area of line 13, the administrator, previously it read that the administrator has management of the fund. That's been removed there. On page 2, line 15, it reads that the fund shall be administered by the Attorney General. Then on lines 17 through 24, most of that's new. The fund shall be non-lapsing, continually appropriated to the Department of Justice on line 17. Then on line 18, the fund shall be non-lapsing, continually appropriated to the Department of Justice until June 2032, at which date the fund shall lapse to the Revenue Stabilization Reserve Account instead of the general fund. That's the formal name for the rainy day fund. Then the following line used to read that the administrator would make the determination of whether it's when the fund is discontinued, and this is added to allow for consultation between the Attorney General and the administrator. The next sentence makes it clear that the settlements will be paid according to the process laid out in the bill. And then the last sentence provides that the Attorney General may enter into agreements with the judicial branch or other agencies to compensate them for services related to things performed in accordance with this chapter. And if we flip all the way to page 8, on line 23, it reads, if the administrator determines that a shortfall in the White EC settlement fund is likely to occur, the administrator, in consultation with the Attorney General, shall request funds from legislature. Similar change on line 35, the administrator, in consultation with the Attorney General, shall submit a quarterly report. Then the last changes are in section 4 on page 9. That was changed from the general fund to the Revenue Stabilization Reserve Account. And the final change is that any unexpended fund as of 2032 will lapse to the Revenue Stabilization Reserve Account instead of the general fund.
I'll come to you in a second, Representative Umberger. It seems to me, I think we also talked about adding a sunset provision in here to close the law out at some point. Did you think about that, Mr. Hoffman, or did we confuse you?
I think that was the last item on the Attorney General's most recent list, and we didn't have any information. I don't know if Mr. Formella has information on that today.
Yeah, so our plan with that was just to see, once we got to the point where we thought this was in very close to final form, we were going to draft that language. So after we get through today and we hear the committee's straw votes on the various potential changes, We were going to plan to potentially work with Kevin on any last minute changes that come out of today. I will also plan to bring some language to whenever that quick work session is regarding sunsetting.
No,
It just,
it's got to be before then. Has to be before then, because that's the final thing.
what's the final thing? Sorry.
You can't wait till Friday or
Oh,
Thursday.
Oh, no, I wasn't going to wait till Thursday.
Okay.
I meant by work session, I meant we were going to plan, and we haven't even told you this yet, Kevin. Bob and I, we were going to plan to get together with you potentially before Thursday just to help to make sure we iron out any changes that come out of today and make sure we get them right, since we know Thursday will be the committee's, or the division's final work session. So we'll have that ready before Thursday.
So when you say you plan to have this work group meeting before Thursday, and today being Tuesday, that means tomorrow?
Yes.
Thank you very much.
Yeah.
Go ahead, Representative Umberger.
Yes, I'm sorry, I do have one other thing, and that is, I've talked to Mike and Kevin about this, and this is on page 2, dealing with how we're going to pay this person if it happens to be a retired judge. Retired judges cannot go back into the retirement system or they're already in a medical thing. So we'll have to kind of firm up some language in there that says if it's a retired judge, then, they don't get the benefits, or we'll give them the benefits and, the same monetary benefits as if they were collecting them, or, so.
Okay, so the bottom line on your comment is we need additional language to handle the special case of a retired judge, just for, yeah,
That's correct.
all right.
Okay.
Okay, so let's stay focused on Mr. Hoffman's review of the inclusion of the 3 financial elements. Are there any questions of the committee? Representative Wallner?
Thank you. So I wondered what the thinking was behind using the revenue stabilization reserve account instead of existing revenues. And secondly, I'd like a refresher about how we open up the rainy day fund. I thought there were some very specific guidelines, standards around how we move forward with opening up the rainy day fund.
To answer your second question, there are, and that's why this is written the way it is to bypass that requirement. So that the legislature doesn't have to vote specifically on opening the rainy day fund, but rather through this bill would approve using the dollars out of the rainy day fund.
Do you want to continue that conversation, Representative Wallner? Are you satisfied?
Well, I guess I would like to know what the thinking is behind using the rainy day fund as opposed to our revenues that are coming in. Our revenues have been coming in quite strong. And it seems like we do have funds available at this point.
Part of the thinking behind that, if I could, is that we currently have about $328 million worth of bills that are before either the House or the Senate, and that obviously spend money, and those monies would be coming out of the revenue that is over projections. And so we wanted to be able to fund. It would limit our ability to fund some of the necessary bills that we have out there. And that's why we opted to go to the revenue stabilization account. May not be the best logic, but that was the logic that I used.
Great, thank you. Could I ask one more question?
Let me just jump into this conversation, and then don't forget your question. So I don't know. I'm still a neophyte in many ways to the things like the rainy day fund, but it seems to me that given that we're going to be paying cases dating back decades, that those were liabilities that we actually accrued long ago, and that the monies from general revenues have added to the rainy day fund over those decades. And so therefore, if we were just trying to match liabilities to the right funding stream, there seems logic to me of using the rainy day fund instead of the current year's revenues. Does that pass the common sense test to you, Representative Umberger?
Absolutely.
Do you have a question? Go ahead.
Yeah, I do have a further question. I wondered if there had been any conversation with Ways and Means about the use of the rainy day fund as opposed to the just regular revenues that we have coming in.
We have had conversations with Ways and Means, not particularly dealing with what our conversation with Ways and Means was is what do we anticipate the excess, maybe that's the wrong term, the revenues to be, and what would be available. But no, I did not specifically talk to them about the revenue stabilization rate, or using the revenue stabilization money.
So you're done then, Representative? Okay. So I think I'm going to try a quick straw vote on this particular issue just to make sure that I know how to conduct a straw vote. What I'd like to do is ask for a show of hands, and I'm going to ask basically two questions. One is, are you in support of using the rainy day funds as the source of funding for this settlement fund? And then the alternative question is, do you support instead using current general funds for that purpose? Would that get at your issue, Representative Wallner?
I think so.
All right, so I would like a show of hands, please, and Mr. Clerk, if you could just help me with the show of hands count. All those who are in favor of using the rainy day fund to finance the settlement fund, please raise your hand. Clerk counts 10. Those in favor of using current general revenue, please raise your hand. The count is 5. So we have 10 to 5 to continue to leave the language in for the rainy day fund. I didn't notice any discussion around the first two bullets that that Mr. Hoffman talked us through, the control of the fund and how we would handle reimbursements. Are there any issues there? Does anyone have any concern, or can I just assume that we're all okay? Go ahead.
Would it be possible for Mr. Hoffman to again point me to the right place in the document to find that?
To find which?
Well, I want to know about the reimbursement to other agencies.
Yes, the language for reimbursing other agencies is on page 2, and it starts on line 22.
Could I ask a question about
Please.
So, when you talk about it, when it talks about any state agency as necessary to compensate them for services performed, who do you have in mind other than the Attorney General's office?
If, if I might,
Please, go ahead, and your microphone's still on, Mr. Yeah.
okay. There may be some requirements from Health and Human Services to go back into records that they may have dealing with the people that were incarcerated. I think that's the primary other agency that might require additional funds. If they had to, hire somebody to do that work for them.
Go ahead.
So this probably is more of a question for the Attorney General. What I am wondering is, would you put some?
Come on up, Mr. Formella.
It's probably really quick. It's either probably a yes or a no, but and I can imagine what it will be. Would you put some limit on the amount that another agency was able to take from this fund? I mean, basically, it's coming out of the fund. So every
Yes.
time someone gets money out of the fund goes down unless for the victims. So how would you monitor that?
Yes, the goal would be to minimize the extent to which the fund is tapped as much as we could. I mean, I think to Representative Umberger's point, that there could be some additional assistance that HHS perhaps needed to employ to help them go through records. I mean, we would certainly work and try to identify any other option that wouldn't require spending money out of the fund first. But, if we get a flood of claims and we had to bring in some outside help on a temporary basis, that would just leave that option open. The other piece of this that is possible is that the administrator has the option to employ staff, and it could be, and we'd have to work this out, but it might be that the administrator perhaps might borrow staff from another agency, but the fund would reimburse the agency for that staff's costs. So there are a couple of different things that could play out with something like that, but we would of course try to spend as little out of the fund as possible. I can assure you that would be my goal.
Go ahead, follow up.
And I guess my follow-up question would be, will there be an accounting of that separately so that we can see how much is coming out? And in addition to that, I mean, you mentioned Health and Human Services, which I think probably backs into some of the things that were said in the original fiscal note. And what I'm wondering is, I mean, that was an agency that had a $100 million lapse last year. So would you encourage them to look within their own means first before they came to this fund, which is really a fund for victims?
Yes, absolutely. I mean, I'll just say it here since we're in session. It would be my sincere hope we would not have to tap this money for that purpose, because to your point, Representative, I think HHS should be able to identify resources within HHS or shift funding around within HHS to cover the need. I think what this allows, it's just, again, we can't predict the future. God forbid we have another COVID surge or something, and depending on what HHS is going through, if we had to tap the fund to get them a little bit of temporary help to make sure we don't end up with a backlog of claims and have this process go off the rails. That's really what this is for. It's a fail-safe, if you will. But I think it makes sense to have it as a fail-safe, even though we'll do everything we can not to use it.
Go ahead.
Thank you for that, and I do hope that you'll be very, very careful about the use of these funds, because they are the funds of the victims.
Yes, we will.
Representative Wallner, I believe in here there's also a requirement for the AG to come to fiscal with their spent money, is it every quarter or?
Yes, quarterly reporting.
So they won't be frivolously spending money, okay?
I'm glad to hear that.
So Representative Wallner, we're gonna be in here for another couple hours probably. If you read lines 22, 23, and 24, and you want to parse the words slightly different and throw the word minimally necessary or something in there, I think we could consider that. I don't think it changes what the intent of the AG is, but it may be worth it if it buys you peace of mind.
No, I think the AG will be very careful with the funding.
All right, thank you. So with that, I think we've can assume a consensus on the 2 bullet points on control and the reimbursement to other services. Representative Walls, question?
Yeah, actually, I want to go back and revisit something. My understanding is, let me move this over. My understanding is this is a meeting of Division 1 and Division 3. Yeah, it just occurred to me afterwards that we've got people from Division 2 voting, so we count their votes. And I'm wondering how that works, because not everybody from Division 2 is here because they weren't on notice. And I'm wondering why we're allowing this to be such a lopsided vote when people from Division 2 are voting when this is not a Division 2 hearing.
I think that's a very fair observation, one that escaped me, but it's in plain sight. So if you are a member of Division 2, raise your hand, please. Okay, there's Representative Lynn, and go ahead,
yeah.
Representative Umberger.
Yeah, Representative Lynn was asked to be on this committee by you as a voting member. He was not put here because of him being on Division 2. So he's been part of this group, okay? And I just happen to be the chairman of finance. I don't have to vote, but I felt I could, as the chairman, that I can vote on any of the committees. So that's, but if it would make you feel better, I don't have a problem not voting, okay? It's,
So could I make a request, Madam Chair, that for the purposes of these straw votes, that Representative Lynn and you don't vote, but I want you to continue to actively participate with your opinions and questions and thoughts. But to Representative Wall's vote, I don't want to make it look like we packed the court. So let's revise the previous 10 to 5 vote to 8 to 5 if we.
that's certainly fine with me.
All right.
And with me.
Is that adequate, Representative Walls?
It is. For whatever reason, the Democrats did not get all the replacements for this today. I'm not sure people knew there was going to be voting, but it's the way the game is played, so I think it's fair.
All right, good. Thank you. So I'm going to try this a third run. I think we've now gone through Mr. Hoffman's points on control of the funds, reimbursement to other departments, and use of rainy day funds, and that we're all in agreement with the language that he's incorporated as a result. Okay, so with that, I think we're ready to move. Go ahead, Representative Emmerich.
Yes, I just wanted to, we hit a glancing blow on page 2, lines 32 and 33, having to do with the compensation. And I talked to Attorney Ramsey about this last week, and I think it would be better not to specify what the administrators to be paid, because this is fixing the salary, fixing the compensation, and I don't, that doesn't give judicial any negotiating room. So I think that should be taken out as you're going through using retirees or not retirees. I think the position should be defined as a 1099 position, which is how I understand it. And so they're not going on the payroll as an employee. They're a contractor. How that works with retirement, I'll duck on that one. But I do think you ought to take out the Superior Court Justice compensation, because that's, now you got a stake in the ground that negates any negotiation with an administrator.
Representative Walls?
Well, to that end, I would, whether we use a judge's salary or not, I'm less concerned about, but I'd like something in there so that you could have a part-time person, because this isn't going to be a full-time job all the way through the process.
Can we defer that conversation, because that's specifically on the agenda where we're going to talk about the part-time aspect of this.
Well, I'd be happy to, but I just want to say they seem to go together. Because if you've got a fixed judge's salary, it's harder to do a part-time, where if you take a part-time job and put it, say, on an hourly rate, perhaps the same hourly rate that a full-time judge gets, then you can have something that's more flexible with the needs of the job. That's why I brought it up now.
Thank you. I've never hired a judge or an administrator, so I'd like some advice from the person that's going to have to do it. What are your thoughts on this?
Thank you, Representative. I'm open to that concept. I mean, from a recommendation standpoint, I would recommend that perhaps we do, if you're willing, defer that discussion to when you walk through Claimants Counsel's points, because I think they kind of address that in one of their points, either making the person part-time. And I think as part of that, to your point, Representative Emmerich, I don't see any harm in, say, capping the compensation at what a Superior Court judge gets so that you're not paid more than that. But if you're going to have potential for part-time, maybe making that a cap as opposed to designating that the salary, then there's some room for negotiation.
So if we followed your thought there, we'd be modifying line 32 on page 2? And we'd be
Yes.
modifying where it says the same salary,
Yes.
that it would be capped at no more than the
Sure.
salary.
Yes.
Okay. Do you have that, Mr. Ripple? Okay, good. Any further discussion on that? We will be talking about the part-time issue.
The way it is now, there is a judicial retirement system. Once you're into it, you can't decide to go and do further work that isn't entered into that. And the judges have to contribute 10%, I believe it is, to the retirement system, and the retirement system contributes the same, and there's a pool of money there that's there and I think that's fairly stable in that one. But so if someone is hired at a judge's salary, they don't have to contribute the 10%, but they don't have the 10% contribution going into the retirement system either. So there's some adjustment there to figure out, well, you're winning and you're losing on those deals, so that has to be balanced. Thank you.
Okay, so Representative Emmerich, are you satisfied with what we just did there? All right, so at this point, we should invite the Victims' Counsel up. Mr. Formella, thank you for coming up, and there'll be more. I think Mr. Don Beard, is it Beard or Bard or? Oh, I was told Mr. Vincianzo, which was a great relief, wasn't going to be here today, and that Don would be.
Because you can't say.
Yeah, because I can't say his name. It really is what it is. So you're here to represent the summary of the 10 bullets. Oh, fantastic!
That's correct, Mr. Chairman, and thank you. Yeah, and so we brought two people. I'll give you two names that easier to pronounce than
Good.
Dave Vicinanzo. So, I'm Jim Hayden with the law firm of Nixon Peabody and a partner of Dave's, and with me is Dan Dean, another partner with us, and he's part of our team regarding the victims of the YDC abuse, and we wanted to tag team today to try to make this go as efficiently as possible.
Could you spell Dan's last name?
Deane. And Hayden with one T. Thank you. There we go. Thank you. So we, as you see in front of you, we focused our comments to to the draft, the Attorney General's last recommended amendment, as a way of sharpening the focus for this meeting. I would say I don't mean to abandon the issues that Dave has raised before, but I don't mean to repeat them here. And we have stated our position very clearly in relation to expanding the full scope of this bill. And there's an amendment that could be considered if you were to go down that road based on a prior draft. But for today, we're going to focus on specific provisions of the bill that we have that seem to be in front of you. I don't have an opinion about the changes previously discussed relating to the rainy day fund. We weren't really prepared to think about that today. But certainly, as I listened to comments about the Attorney General controlling funds, I don't know where to come down on that issue, but I just want to remind the committee that, every day that this bill does things like that, the question really is going to become whether you're actually establishing a trauma-informed, victim-centered alternative to litigation, because we're clear that we think there should be a process that's inviting to every victim, not just a select few. And with that, as you'll see on our summary, we have 2 points relating to the physical abuse definition that was added to the draft last go around, and for that I'm going to ask Dan to explain our comments.
Thank you. I want to hear you. I just want to make sure I'm following in writing exactly where we are and what we're looking at. I see your red line version. Are we off of your red line version, or are we off of the last official version the committee used?
We're working off of our red line version. We didn't have that.
Okay, so in this example on line 36, you added a single incident of, for example, is that where we are?
Yes, that's right.
Okay, I won't interrupt you further.
Okay. I'm actually going to talk kind of in conjunction about both the first 2 points, because they're similar reasons for these changes. It's both to the definition of physical abuse and sexual abuse. And, as Jim said, we're not going to repeat all the kind of core principles that David had told you about in prior meetings, but, this goes to that kind of core principle of covering everyone and being comprehensive with a alternative dispute resolution process. And we think that's, in the claimant's best interest and also in the state's interest to resolve, to the extent it can, to resolve these claims through this process and not have a situation not only where you're discriminating against some members of this class, but there are possibly cases that we identify in here. I can give an example where you could have a survivor who is both making claims under this process, but is also being denied, even though the claim might itself be valid in court. And so they have to then, they might get a settlement out of this process, but then they still have to go to court because some of their claims are not covered by this. And so that's why, and the other thing that I'll point out too is that, you can see in the revision we've made on both physical abuse and sexual abuse is we've added reference to the common law definition of assault and battery for the physical abuse, and then for assault, and then referencing the criminal definitions for sexual contact and sexual penetration. So the theme here is what the state wants to get out of this process, besides trying to make these survivors whole again or give them some compensation, is at the end of the day to get a release of civil claims and civil liability. So we think it is important that the concept of civil law is incorporated and we're not just focusing on criminal statutes. So let me give you the example that I think really points out the issue that we have, especially on the sexual abuse definition. So the Attorney General's proposal, and we understand why they did it this way. They wanted to make it fairly narrow to address this specific situation. There's sexual assaults occurring in a juvenile detention facility. But it just cuts too thinly. It slices too thinly. And I think we saw evidence of some of the complications that causes during the last hearing when Representative Lynn had some concerns about the carve-out they had to make. That was caused by the fact that they're slicing this so thin. So the example I'll give you is supposing there's a 12-year-old that's detained at the YDC, and they are physically assaulted, thrown to the floor, and raped by a janitor. That is going to cause an issue when the administrator has this case. The administrator is going to have to look at, well, did this person have direct supervisory authority over this victim? They're the janitor. They're not a guard. They're not a counselor. And when you look at the statute 632A2, so for felonious sexual assault, 632-A2, if you have a brutal rape of somebody that's 12 years old, that is very easily covered by several provisions of the statute, including the very first provision, which is when a perpetrator overcomes the victim through actual application of physical force and physical violence, and also subsection L, when the victim is less than 13 years old. But instead, we're asking the claimant in this process to have to prove N, that the perpetrator was in a position of authority over the victim and used that authority to perpetrate the rape. And it even goes further than that, when the actor has direct supervisory, disciplinary, or other authority authorized by law. So this is adding elements and complexity to the process for reasons that we don't understand and don't seem to be victim friendly. So, and kind of returning to my previous point, at the end of the day, we're looking for a release of civil claims. If this claimant goes to court, they wouldn't have to prove this whole supervisory authority piece of this. They would just prove I was physically assaulted and raped. So we think this process should mirror what would happen in court if you're going to get a release of liability. And as I mentioned before, you could have the same claimant that has multiple claims. So and we've seen this in the files that we've looked at. We have claimants that are assaulted and raped by multiple different people in multiple different positions within the YDC. So there could be examples where you have somebody that wants to go through this process and they're able to resolve some of their claims, but they have other claims that they have to go to court to resolve. And that would seem to defeat the purpose of the statute.
Let me check in with Representative Lynn here a second. In an earlier conversation, you were trying to educate me about the FOSS language. Is the substitute language that you developed around that applicable here on these particular lines?
Yes. I mean, I think generally I don't have a particular problem with what counsel is saying here, with the exception that my problem was carving out that exception with the false language. And I note that in his proposal, he continues to leave the false language in there, which would carve out that exception, which I think would make the state's liability too broad. But I do agree with him, and in fact, the way I had proposed to cover the situation that the Attorney General had adopted or had pointed out was to say that it could be a common law claim. It could be a common law claim for civil sexual assault. So I think generally I don't have a problem, but I would still take out the reference to accepting state versus false.
Representative, actually, I agree with you on that. I think if the other changes are made that we've requested, I think we're fine with striking that. It's kind of redundant to have that language. It's not necessary.
Oh. Yeah, so I mean, I would be okay now. Obviously, I speak only for myself.
Your opinion matters. Is this the section that you drafted alternative language?
I did. Mine isn't exactly the same, but
No, but this is the exact section.
Right, it is the exact section, yes.
Would you read verbatim the language you proposed,
Oh,
please?
sure, yes. What I had said was in subsection I, sexual abuse means conduct which would constitute an offense under RSA 632A21N, RSA 632A34, or RSA 632A43, or a basis for civil liability for sexual assault under the statutory or common law of New Hampshire. I think that's probably, I think it's pretty close to what you had drafted.
From the victim's perspective, does that make sense to you? Could you live with that language?
So I guess we didn't have a chance to prepare, but to answer your question, it does make sense to me. It kind of goes back to the theme I was saying at the top. At the end of the day, the state wants to get a release of civil liability. We're not talking about prosecuting these people through this statute. We're talking about civil liability. So I think going back to the common law, now with the sexual assault statute, it is helpful, the criminal statute, in defining what is sexual contact and what is sexual penetration. And I don't know that there's that much clarity in the common law. Maybe there is, but that's why I still included a cross-reference to those provisions. But yeah, I mean, the general notion of this should be as encompassing as the common law makes sense to me.
And I would just say, Mr. Chairman, I don't, if we took out the reference to the State v. Foss case, I personally don't have any problem with the way council has drafted the sexual abuse definition.
Okay, so in order to feel like we're making some progress, I would like to do a straw vote. And I guess the straw vote is really on item 2, not item 1, since we're talking about sexual abuse and not the physical abuse line. So what I would like a vote on is raise your hand if you think that the alternative language that Representative Lynn has drafted, if we should use that as alternative language to what's in this now. And then the opposing vote will be, we'll have to keep talking about it. Go ahead, Representative Walls.
Given that everybody agrees on the plaintiff's language, I'm wondering if that's the language we should be voting on. Since there seems to be some slight discrepancy with Representative Lynn's, but everybody seems to be in agreement on the plaintiff's language.
I don't know that I share the assumption that everyone agrees with the plaintiff's language. I do tend to want to defer to a member of the legislature when drafting legislation, and he spent some considerable time looking at this issue.
I don't want to overstate what I meant by everybody. I meant by Representative Lynn and the plaintiff's attorney. I meant both of them agree. That was what I meant by everybody, not the whole committee. But I heard both of them agree on the plaintiff's language. So that's why I was suggesting that might be what we should be voting on.
So rather than speaking for you, Representative Lynn, I interpreted you to have distinct alternative language to what the plaintiff has offered.
Yeah, well, that's true. I mean, my language is a little bit shorter than what council had proposed. But as I said before, I think if the only substantive difference, as I see it, is that if you take out the language, the reference to State versus Foss, which, as I understand it, council agrees that he would agree with, then I don't really think that there's any substantive difference between my language and his language. His is a little more detailed, but I think substantively the two are the same.
So I need to take this down to like the 101 level instead of the 501 level. I just need which paragraph will go in. Is it your position, and it's got to be kind of a binary thing, that we should accept the plaintiff's language or that we should substitute your language? Just which one?
I would use the plaintiff's language with the striking out the state versus Foss reference.
Thank you. Representative Griffin?
Thank you, Mr. Chairman. I believe that the legislature should do the drafting, and therefore I would like us to use Representative Lynn's language. And that's the question you originally raised, and I'd like us to vote on it.
Yes.
All right. You still think that, even though Representative Lynn has changed his position a little bit, made it okay? We can do that. Representative Erf, did you have a question?
I agree with that perspective.
Okay. So we're going to go ahead and do the straw vote. We're going to vote on bullet 2. Show of hands at this point indicates that you support the use of Representative Lynn's language. And then the second vote is going to be if you prefer the plaintiff's language. Okay. So is it clear what we're doing? Okay. Raise your hand if you think we should accept Representative Lynn's alternative language for this bullet 2 item. So the clerk counts 5. Now we're going to go the opposite and say accepting plaintiff's language. Raise your hands.
1, 2, 3, 4, 5, 6.
So that's clerk counts 6. So that's 6-5 to go with the plaintiff's language for bullet 2.
Mr. Chairman,
Representative Erf.
are we still striking the language that Representative Lynn referred to? And if so, I'd like to know exactly what language that is that's being stricken.
I think what we just said was that we would accept the language for lines 39 on page 1 through page 2, line 1, in accordance with what the plaintiffs have written. That's what I think we just voted on. Is that, correct me if I'm wrong, Representative Lynn?
I think the language that I understood you voted on and got the 6 votes was that you would take out the language that begins on line 40 and that says, except that coercion as interpreted in State v. Foss, 148 New Hampshire 209, 202, to require an affirmative act by the perpetrator shall not be required. You take out that language, but other than that, it would be the sexual abuse language used by the claimant's counsel.
So delete starting on line 41 of the plaintiff's document where it says accept.
Except, that's right.
And then continue the deletion until we get to the next page. To what word?
The word required.
To delete the word required.
Delete the word required, exactly.
You have a problem with that, Mr. Dean? Mr.
No,
Hayden?
that works for us. Thank you.
Okay, so let's do it that way without revoting. Thank you. Okay, so let's go back to Mr. Attorney General. Did you have an issue with that? No. Okay, I don't want to assume. I don't want to. Okay. Okay, thank you. So I think we skipped over item 1, though.
Yes. So item 1, physical abuse. Our edits there are essentially the same. It's the same concept that we want to incorporate the common law causes of action, in the definition of physical abuse, since again it is the common law claims that the claimant will be releasing.
Any comment from the committee?
I think I don't have a problem with what plaintiff has proposed there either, because I think if something is a common law is a common law basis for liability, then the state should assume that responsibility.
All right, and Mr. Attorney General?
So I don't have an issue with, I think, the language regarding including common law causes of action, but changing the specific offenses to all of RSA 631, I would recommend at least that full change, because RSA 631 includes things such as reckless conduct, criminal threatening. You know, something like criminal threatening is not something that I think we should include within the definition of physical abuse.
So it sounds like the carve-outs that are in here for 631.1, 631.2, 631, I guess 2 is repeated, I'm not sure what that is. 2A. You would recommend that we keep that and not go to a blanket?
Yes, because that's first degree assault, second degree assault, simple assault. You know, the rest of that chapter or section is domestic violence, reckless conduct, criminal threatening, conduct involving laser pointing devices, failure to report injuries, or student hazing. So I think we should stick with those specific carve-outs.
Thank you. So, Mr. Dean, Mr. Hayden, do you have any violent opposition to what the Attorney General just said?
No, I don't think we have violent opposition. Assuming the common law causes of action for assault and battery are included, I think we can live with that change.
I think we're open to the common law. Okay, so I don't know how to straw vote this one because it requires me to remember. So I think what we're going to do is we're going to change 36 to read, physical abuse means a single incident of conduct that would constitute an offense under RSA 631.1, 631.2, or 631.2 alpha, and that is not justified under RSA 627:6, or a common law cause of action for assault or battery. Okay, so we're going to do a straw vote. If you accept the language as I just read it, you'll raise your hand. If you want to do something else, we'll talk about it some more. So show of hands, do you agree with the way we just rephrased it?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12.
The vote is 12. If you're opposed to accepting that language, raise your hand. Nobody left. Okay. That makes sense, right? 8 plus 5 is 12? Yeah, got it. No, 5th grade. I'm still using that knowledge. So we've gone through 1 and 2. Do you want to pick up 3 now?
I do, and thank you. That's one for me, Mr. Chairman. The comments in section 3 are on page 2, starting at line 20. And really, the idea of these changes was, we wrestled with some of the issues that Representative Weiler and Representative Emmerich discussed in the context of that, the folks who are going to be qualified to be administrators and agreeable to both the Attorney General and our firm are unlikely to be people who are willing to abandon their career and become a full-time employee of the state to run this process. And that'll certainly be true in the early stages as they ramp up. So we thought that we should add to this bill the opportunity to allow for a part-time administrator. And then, frankly, I just made the part-time administrator as qualified as the administrator that we've defined, and later on basically saying that that part-time administrator would be paid at the same compensation rate as a full-time judge. So really to build some flexibility into this as we move forward, and frankly is a way of streamlining the process, I would hope, to get the right people in the right spot so that we can advance discussions after this bill is passed.
Okay, so let's pause there because we've got a clear break. On the first half of 3 asks for the ability to permit a part-time administrator, And earlier, we talked about imposing a ceiling for the salary, not a description of the salary. So if the committee were to accept a part-time with a ceiling of being paid at the judge level, is that acceptable to y'all?
It is acceptable.
Okay. Mr. Attorney General, do you have an issue with that? Are you still back there?
I'm
Oh,
right
there
here.
you are.
I moved here just so I had a microphone, just to make it easier. That's fine with me. I think that makes sense.
Okay, great. Let's put a pin in that and then move on to the
If-
second, Representative Umberger.
Yes, thank you. If we're going to go to a part-time, then we need to describe how we're going to come up with the salary. We can't just, we can say that if you're full-time, you get X, but if you're part-time, you have to get Y.
So my understanding of that is if we impose a ceiling, anything below that ceiling for a part-time person could be negotiated. Is that not adequate?
By whom? You gotta say.
Oh, by the Attorney General, aren't the
No.
Attorney General's the gatekeeper to the hire process, isn't it?
No, the Supreme Court is.
Okay.
Okay, the Attorney General and the Council submit the names to the Supreme Court, and the Supreme Court chooses whoever. So we need to have something in there that says somebody needs to figure out how much we're going to pay the part-time person, if in fact that's what happens. And, oh, by the way, I don't have any suggestions.
Okay, so that'll save me that. To me, the notion of being able to go to a part-time administrator just makes sense in year 3, 4, 5 in particular. I have no idea on how to set up the language to negotiate a part-time salary. Representative Walls, do you have a great idea?
Well, I don't know if it's great, but I have an idea. And that is that you take the hourly value of the salary and benefits of a full-time judge, and you compute that out, and that the part-time administrator is paid at that hourly rate. But I think you'd want to include both salary and benefits, the value thereof.
Do you have language that you'd propose?
I probably could create some. I'm sure anybody else here could too. That's not that hard to create. Just that the payment to the administrator shall be at a rate the equivalent of the hourly cost of salary and benefits of a full-time judge.
It sounded good to me. Representative Formella, excuse me, Attorney General, I didn't mean to do that to you. General.
Yeah, I think Claimants Council had started to get at that concept, and I think the one thing we would really be adding here is that we're capping it at the annual salary of a judge, but I think making it so that the compensation is at an hourly rate that's equal, and as long as it can't exceed what the salary and benefits would be total, I think that makes sense. So I think we can iron out that language, but I think those concepts make sense.
So I assume the working group tomorrow could work out language that meets that, and I'm going to assume there's no opposition to that. Representative Irf, go ahead.
There may be. I don't think, it's nice that I understand the calculation, but it shouldn't be a straight hourly rate, period. That basically would put it way over, could initially put it way over in the first year if the guy's working way beyond 40 hours a week. So I think it should be capped at an annual rate as well.
I would tend to agree, and that's what I thought we did when we capped it to begin with. Representative Lynn?
Yeah, can I also just raise an issue? I think it would need to be very clear in the definition of benefits that it doesn't include the benefits, the retirement benefits cost of a Superior Court judge, because you're talking, if you include that, you're talking about 75 or 80% of the judge's salary for retirement benefits. It's very, it may be a little bit high in that, but it's very high. It's very high, and I don't know that you want to include that. Health insurance, things like that, that's one thing, but the retirement benefits, I think probably not.
Okay, so two things that Representative Burp and Lynn have kicked in is that we should have a total cap, I think, at the judge's annual salary, and that in the calculation of benefits, that we would not include the retirement benefits.
The cost of the
The
retirement.
cost of the retirement benefits. So since you all are going to do a working group tomorrow, I'll let you wrestle with the details.
Sure, that
Ru-
sounds good.
Mr. Hayden?
Yeah, if I could offer, part of the reason for going to a part-time position is that, frankly, these folks aren't looking for benefits, because they have their independent law practice or mediation practice. So it's not as if qualified people would really care about benefits. So certainly could say that a part-time would not be entitled to benefits.
Mr. Hayden, I think I spoke to the value of the benefits, not the benefits themselves. I was trying to make the compensation equivalent. That's why I addressed the value of the benefits.
Okay.
All right, so I tend to agree with Representative Walls on this one. So, but I'll just trust that the folks drafting language can figure out the right way to carve that. If there's not any opposition, I won't do a straw vote. All right, so now I cut you off, Mr. Dean, at the second paragraph at 3. Is that worth talking about?
So it's worth talking about, and it's on 31 and 32. That's later on. That's the compensation. So if you look at the second sentence starting in line 24, this is a provision that basically says if the Attorney General and us, the counsel for the claimants, can agree, well, there's no need for the Supreme Court to pick an administrator. So really what's trying to eliminate that need for that step in the process if we can come to an agreement with the Attorney General as to who might be the administrator. It seems an unnecessary step.
So you're just recommending an efficiency step, and if you guys agree to begin with, you don't need to go to the Supreme Court. Otherwise, if you don't agree, you'd still go to the Supreme Court.
Correct.
Representative Umberger?
Yeah, we just have to remember that the Supreme Court is the one that appoints the person. Okay, so if they go with everybody's in agreement with John Doe, then I would have to assume that the Supreme Court would appoint John Doe.
So that's rational. If they just forward one name with the information that we've agreed on this, please put a stamp of approval on this, then it's still the Supreme Court or appointment. All right. Is there any opposition to that? Anyone on the committee? So we'll go on. I think we can do that with the work group. Then we'll talk about number 4. Adds false imprisonment as an aggravating factor. Do you want to speak to that?
I'll speak to that one because this is following my common law theme that I started with the first 2 points. So this is going back to the core issue of including all survivors. We've at least for now let go of the fact that false imprisonment would be a separate claim, standalone claim for this process. However, the Attorney General has included the idea of unlawful confinement being an aggregating factor that the administrator could look at in determining a value of a claim. So we've added false imprisonment, which is really the common law term for what I think the Attorney General is getting at with unlawful confinement. There is a definition for unlawful confinement earlier in the definition section. It's I would say a little more complex than it needs to be, and it throws up a lot of potential defenses that the state might raise. Now, when we incorporate false imprisonment, that's not to say the state is defenseless. There's at common law there are justifications for a false imprisonment case, so the state will have defenses, but again, this goes to my theme of let's stick to the common law.
So help the non-lawyers here. We've gotten a little used to hearing the term solitary confinement. To what extent are these the same terms, just said differently, or are they different theories?
Well, solitary confinement is something that might occur at YDC. Somebody might be placed in solitary confinement. It's not a cause of action, though. It's not a cause of action at law, at common law, to bring a claim for solitary confinement. You'd bring a claim for false imprisonment, which is, to cut to the chase, an unjustified imprisonment. With and I think the common law will provide the same type of defenses, the same type of justification defenses that the state might wish to raise as they've included in their definition of unlawful confinement.
We'll do Representative Weiler and then Representative Walls.
My feeling is that the original sentence to the YDC could be interpreted as false imprisonment, and it's like appeal court, going back over why were you sent to YDC, and we'd have to relitigate that whole thing over again. I think it really opens the door and broadens everything and makes it more expensive and more difficult. I'm not in favor of that.
Representative Walls.
I just want to say I've toured YDC a few times. And in addition to locking people in the room, they have a chair there that they will strap you to. And they claim they've used it only when somebody's out of control, but I have no knowledge of when they used it. I just want to keep in mind that there's multiple ways of confining people here that may or may not have been used appropriately. And I just want to do whatever definition we've got that encompasses not only locking somebody in their room, but strapping somebody down as they have apparently done there.
So my general concern is just scope creep on all of this, and so it wasn't included originally. Mr. Attorney General, would you tell us your thoughts on adding this?
Yes, thank you, Mr. Chair. I understand what plaintiff's counsel is going for here. I don't think I would recommend adding this as an aggregating factor because, as Representative Waltz said, and I don't mean to interpret her comments as agreeing with what I'm saying, but as she said, there's a lot of different ways you could confine someone that some might view as false imprisonment. For instance, the use of restraints at YDC. My impression is that's not what this bill is going for. This bill is not meant to sort of retroactively evaluate the practices at YDC. I struggle to come up with a hypothetical where something other than unlawful confinement or solitary confinement would make sense as an aggregating factor for physical or sexual abuse. I suppose if one were, given that these are individuals who are already incarcerated, perhaps you would have one hypothetical where someone was in a locked room while they were being abused and someone else was perhaps not. So it strikes me as more of a risk for scope creep than it would be a benefit in covering claims that wouldn't otherwise be covered. But I know I'm not supposed to ask questions because I'm not a member of the committee, but I would be curious as to whether plaintiff's counsel had a hypothetical where false imprisonment might be an aggregating factor.
Mr. Dean, let's make it a debate society. Do you want to respond to the
Sorry,
question?
that was just a question of curiosity.
Well, I don't have a particular hypothetical in mind, but it's, obviously it's not the intent of this change, and this is only to aggregating factors. It's not to adding a new claim. So it's not an intent to relitigate the reason why the claimant is in YDC to begin with. It's just, to the extent they had some freedom to be in a general population and then they are unjustifiably removed from that and put into a solitary confinement for weeks or months at a time, that could fit a common law claim, I believe. And so we're just trying to, get what we can, and we understand that we're not going to get a standalone claim here for false imprisonment or solitary confinement or any of those. But as an aggregating factor, we thought that it was fair game.
All right. I think we're ready for, Representative Rogers, please. And do wave your hand at me, because there's the visualization's blocked a little bit.
Okay. No, I just think that adding it's an aggregating factor they're talking about. It's not the single claim. And we've heard number of instances on the claims that have already been brought to court of elongated time in solitary confinement. And we keep in mind this does go to a mediator. This does go to someone that's going to make a judgment on it. I think it's important to have in there because we've seen time after time of example of the solitary confinement being, in my mind at least, abused as a practice. So I would like to see us include it. Thank you.
Thank you for that. Let me ask you all a question. Are we going to have a specific conversation on solitary confinement, or is this as close as we get to it?
This is as close as we get in the changes that we've put in this version, yes.
Okay, so I think I'd like to conduct a straw vote unless there are any other comments. On item 4, a vote in favor to raise your hand is an agreement to add false imprisonment as an aggravating factor. The second question will be opposed to adding it, and I'm going to be voting as opposed to adding it, just in case anyone's curious. So at this point, please raise your hand if you are in favor of adding false imprisonment as an aggravating factor. Mr. Clerk, would you help?
1, 2, 3, 4, 5 in favor.
All right. Those opposed to adding, raise your hand.
1, 2, 3, 4, 5, 6, 7, 8 against.
So we have an 8-5 vote. All right. So bullet 6. Do you want to start bullet 6? Wait a second.
Yeah, there is no 5, so there's actually only 10 issues. We have 9 issues, right? There you go. Now you know the source of the problem. So we did take one off the list just to make your life easier, Mr. Chairman.
Expectation set.
Yeah, thank you. All right, so now we go to page 3, lines 28 to 32. And again here, last time at the last hearing, Dave gave a brief reaction to the notion of having the administrator be the same person who helps with the guidelines, actually end up being the adjudicator of claims. And we believe that having someone who having someone involved in the discussion to mediate the discussion between the Attorney General and us, frankly, would be helpful if we thought it was needed. I think that helps both the state and us to make sure that, to the extent we think negotiations need some help from a mediator, this is somebody who could be brought into the process to help facilitate discussions. It's really just a way of hoping to try to move this process forward more efficiently. And, it would be someone who is not going to make a decision. It's someone who's simply going to offer their opinion to try to move the process forward.
Okay, so I'm reading 28 through line 31 on page 3, and that first sentence of your red line is saying, as I read this, that what you're trying to do is get the administrator in the loop before the I keep calling it a matrix. The claims form is built. You want the administrator in before that's finalized, instead of after it's been finalized. That that's the key thing you're going for in this sentence, first sentence.
Except for the fact that, you know, this is intended to address any concerns if that person would later be appointed to be the full-time administrator or the permanent administrator. In other words, we think, you know, we had talked about having the administrator involved in the process of developing the guidelines. And we would rather say here, okay, well, it doesn't have to be the administrator. It can simply be some other person who would be helpful. And then the administrator himself would be later determined under this bill.
So let me nitpick at the word "or." The Attorney General or counsel for claimants. Should that be an "and"?
No, because I'm presuming that either party, either side believes that it would be helpful to have a mediator involved in the process to move things forward.
This is not having a second person. It's the same
Do you want to speak, Representative Weiler?
It seems like it's the same person. So, okay, you didn't agree with my ruling over here, you're going over here and it's a different situation. Now I'm the mediator. Before I was the administrator, now I'm the mediator. It's the same person. Why would they change their mind over what they've just done?
You can respond if you'd like to.
Yeah, Representative Weiler, we're trying to put someone in place to help the process establish the guidelines. Those guidelines will need to be established before an administrator is picked, right? And so that's going to be a process where we see things may run into troubles. So here we're asking that simply up to the point of determining the guidelines, a mediator could be brought into the process.
So it feels to me like there's an element of potential forum shopping that's built into the "or" part of that, and it seems to me that the Attorney General's office is responsible for coming up with an acceptable set of guidelines, and that negotiation and discussion and accommodation is part of that process. I don't know that I'd want it so easily bounced out of the AG's role into an undetermined mediator's role. And so I'll just ask you, Mr. Attorney General, what your thoughts are on just particularly the first sentence there.
I think my thoughts are that a mediator could prove useful in that process at some point, but I don't. It doesn't strike me that it's necessary to give either party the ability to kind of unilaterally bring the mediator in. I think there should be a discussion first, and perhaps a mediator if each party feels like that would be helpful.
So do we just fix that with changing "or" to "and"?
That's how I would change it. I know, at least my understanding is there's going to be another item further down on the list that may also impact this item. So but yes, for now I would change "or" to "and." I think that would make more sense than having one party right off the bat being able to bring in a mediator.
Representative Lynn?
Yes, thank you, Mr. Chairman. It's my understanding, and in fact, Janet is actually typing up the three things that we had discussed in caucus. But I agree with the idea that that the administrator, who is going to be sort of the final adjudicator, if you will, shouldn't be establishing the guidelines. But as was discussed earlier, it seems to me that while the Attorney General ought to get input from the claimants on what the guidelines should say, the final determination on determining the guidelines should be the Attorney General's to make. He should make the final determination of what the guidelines are.
So if we were to pursue that line of thought, we would just simply not accept the sentence starting at 28 on page 2, starting upon the request of the Attorney General or counsel for claimants, the Chief Justice of the Supreme Court shall appoint an individual with qualifications of an administrator to mediate the development of the claims process and guidelines for valuing claims. I think your recommendation would be just to strike that.
Right, it seems to me that that's sort of, creating the possibility of an adjudicator to decide what's going to later be adjudicated. I don't see any reason to have that in there.
Okay, so the Attorney General has suggested this is tied into another topic we're going to discuss, so I could just defer a straw vote on this until we complete this conversation, I think. You'll let me know when we've completed that conversation.
Sure. Just to be clear, it's only it's an item that I understand a member of the committee was going to bring forward. But yes, I can certainly let you know when I think we've reached the item that makes sense to combine with this item.
Thank you. So then the second part of that item is line 31 starts, the compensation of the individual shall be determined by the Chief Justice of the Supreme Court and paid from the fund. We've already talked about how we're going to write this on so the part-time salary could be determined. So we're done with that? So I think we might be ready for a straw vote on line 6, but I'll hold off. I don't think it's faring well in my view. But so let's go on to line 7. Do you want to talk to line 7?
Okay, so this actually is more of a restating of a position and a comments that Dave has made on a number of occasions, and this is on page 4, line 7 to 10. And so what we have offered here is language that would set the caps on settlements at the current standards approved under New Hampshire law, and that's $475,000 per incident, and then the second one ties to RSA 1435B, which is the aggregate cap on settlements. And the reason for this is generally that we believe the process that's going to capture the most victims who are going to go through it will give them a fair opportunity to recover what they've already are entitled to under law if they can prove their case. And so we see no reason why there would be any need for a cap at the $1.5 million. And, to the extent, there's concerns about amounts that, are going to be settled, compromises that need to be made, those types of compromises will be made in the claims guidelines process as well as the adjudication of claims. So the notion that this $1.5 million is appropriate here, I don't believe is necessary. And, we think that this process should have the same caps that the victims would have if they pursued their claims in a court.
I don't remember the details of that 475,000 being written into the statute, but as I recall, generally that 475,000 was meant to apply in a different scenario, in a scenario that doesn't really match the analogy of this civil procedure. Do you know what I'm talking about? Maybe, Mr. Attorney General, could you refresh my memory on where that 475 comes from and your position on whether or not it's pertinent?
Sure. Thank you, Mr. Chairman. So the $475,000 number is what I kind of think of and refer to as the sovereign immunity cap for many civil claims. The state generally has sovereign immunity that protects it from civil claims against the state, but there are exceptions, and one of the general exceptions is that the state allows recovery of up to $475,000 per incident. That's the sovereign immunity cap. So I think it's not, the $475,000 cap is not meant to be a settlement cap. It's meant to define sort of the upper limit of the ability to recover for each incident for which someone might bring a claim against the state. The limit in 1435B is a settlement cap, or is a cap on the Attorney General's settlement authority when the Attorney General is looking to settle cases. And that is a number that's equal to 0.25% of the previous fiscal year's general fund revenues. I think, as I said last time, I think using that cap and as an argument for why this cap should be the same doesn't quite fit, because the cap in 1435B is a general cap on any potential claim against the state that the Attorney General might settle. And it's roughly $4.6 million. That cap doesn't account for what the specific claims might be, or how valuable they might be. In this case, we developed the number of $1.5 million because we are looking at a fairly unique category of claims. And as we've mentioned in the past, we did the verdict research, we did the settlement research, we've seen what's been paid in other cases involving these types of claims, and that's how we came up with $1.5 million. The $4.6 million cap, again, that's just a general overall cap. So you could imagine particular claims that might be brought against the state that the Attorney General might want to settle for $3.4 million, but those would be very specific facts, very, very egregious, and you do research on those types of claims. In this case, I think we've done the research, and 1.5 million is the number we've arrived at. So I apologize. That was a long answer to your question.
No, it's an excellent answer. I just jumped ahead to looking at the 150,000. Is that 150,000 meant to be the cap for physical abuse only?
Yes.
And how, remind me maybe, how did you come up with 150?
So within the verdict and settlement research we did, there were cases that involved physical abuse claims as standalone claims. It's admittedly, we have less of a sample size for those, but I don't have the chart with me. I didn't bring it, but the average that we identified there was from about 65,000 to 75,000 per claimant. And so while I think this $150,000 cap is fairly classified as a bit rougher of an estimate than our $1.5 million estimate, that's how we got that $150,000 number. I think it's a pretty solid number. I mean, there may be some room to quibble with it, but with the numbers we've seen, I think that cap makes sense for physical abuse only claims.
So I don't want to put words in your mouth, but what I think I hear you say is that your preference would be to maintain the language we had coming into today.
Yes, that would be my recommendation.
Representative Walls?
Thank you, Mr. Chairman. I want to go back to what I was talking about at the end of our last hearing, and that is the purpose of this is to try and keep these cases out of the courts. And the caps that we're talking about imposing here, to me, are a disincentive to use this process, because the plaintiffs would be able to recover potentially substantially more money outside of this process if we leave the caps here, where if we take the caps and raise them to where the plaintiffs have, then it seems to me like more people might be inclined to use this process, thereby saving the state money from not having to hire a lawyer to litigate these cases. So, hang on, I kind of had this worked out in my head. Let me figure this out, where I was going. We're trying to set up a system that the plaintiffs want to buy into. And it seems to me by putting the caps in, some of the plaintiffs are not going to want to buy in. And that is contrary to this purpose. They're not, if they can recover more by going to civil litigation, then it doesn't save the state any money to have the caps on now, because they're just going to then go to civil litigation if the caps are too low for their case, or if they think they're too low for their case. And it's going to cost the state more money because they got to hire a lawyer. So it seems to me short-sighted to put these caps on so long as there is the ability to recover under civil litigation. So you could have a plaintiff choose not to use this process, file a civil suit, end up settling it without the caps, but even perhaps using the same matrix that's going to be done in this system, but they would be exempt from the caps because they went in through the courts instead of in through this mediation system. So I'm wondering, what's the point of the cap if there's an alternative that's just going to cost the state more, but give the plaintiffs the same ability to recover higher than the caps that we're currently imposing?
So, Representative Walls, I agree with your primary premise, which is that if these caps are too low, we will have destroyed the entire purpose of this legislation. And what it seems to me is that there's a balancing act of interests where we want to entice enough people to come into this process because of the simplicity of it, the anonymity of it, the speed of it, the trust that gets developed in the administrator's judgments, that ultimately we have asked so far the Attorney General to weigh the amounts, the caps, so that the enticements are there, but that we also balance the interests of the taxpayers as well. And this has been the Attorney General's, I think, and his staff's best efforts to establish a fair and reasonable cap in order for this whole settlement fund to work in the first place. And I just did put words in your mouth, but do you have any comments on that?
Yes, thank you, Mr. Chair. I would echo a lot of what you said, and just in response to Representative Waltz, I would say, I from the beginning, I think the way we, and by we I mean the Department of Justice, have looked at this is that this is an attempt to, provide an alternative option that again is a easier, smoother, gentler, more victim-friendly, trauma-informed process than litigation, and that also provides fair compensation. That said, I think we've always acknowledged that this would potentially, for some claimants, provide less compensation that they might be able to receive if they went all the way through their case. So if they went all the way through discovery and they got through pretrial motions, they got through dispositive motions, they had a trial, took the stand, got a jury verdict, they could get a jury verdict for more money. That takes a long time. It's not a very victim-friendly, trauma-informed process. Litigation is a contact sport. And I think for a lot of these victims that process would not be appealing. If we went through that process as the Department of Justice, we'd be obligated to defend these cases, and we would defend these cases, and we defend them vigorously. So I think, this is, as I think I've said, from our perspective, it's all about balance. We want to provide an alternative option. We want that option to be much smoother, gentler, more victim-friendly, trauma-informed than the traditional litigation process. But with that, I think has to come a fair valuation of these claims, and the only way, in the context of a settlement process, and the best way I can think of to do that is to look at look at what other numbers have looked like in settlements of similar claims, and that's what we've tried to do. But all that said, I acknowledge that there may be claimants who this isn't enough money, and they think they can get more by litigating, and it's worth it to them to go through the more difficult litigation process to get that higher amount. They have every right to do that. And while I say we'd defend them vigorously, we'd certainly do it respectfully, but we would fulfill our obligations to go through that process.
So I think Representative Rogers had her hand up first.
I understand the Attorney General's view on this. However, taking it from a victim's viewpoint, many of these victims have waited a number of years. So time is not necessarily something that they're not used to having to wait. It's been going on for close to 50 years down. and we could have someone come back that's waited a number of years for it. So I don't think the time argument is necessarily one that all of them are going to look at. The other thing is taking an average, while it's a way to do it, I don't think is a fair way in something like this. Each claim is very different. Each claim is very personal to the claimant. And they've gone through this. They have the pain. They have the suffering. They know what happened. I think a number of them will want to go to court if there's a limit. I don't know if it's something that we can just take out a cap altogether as a compromise between the two positions, but I think that setting an arbitrary number of 150 at this point is just not where we should go. I think that we need to let the claimants know that we're open to whatever's going on. There's some, and I don't think the majority of them are going to be on the high end of this necessarily, but I think that we need to let the victims know that there's a possibility that there's going to be more, and that they don't necessarily have to go to court, that they can go through this process that will be better. Yes, I know the state will vigorously defend something, but that's money and time that they necessarily don't want to spend either, and would rather go through this process. So I would just argue that we should look to not limit it to the 1.5 and look at either the plaintiff's alternative or a compromise of not even mentioning a cap.
Thank you. Representative Walsh, do you still have a comment?
Just real quick, and that is, the Attorney General set up the scenario where somebody would file suit and they would have to go to trial. We know that the vast majority of cases that are filed do not go to trial. They are settled. And what I see happening is somebody files suit and they end up settling, perhaps consistent with the grid that's out there, because it's going to be cheaper for the Attorney General to settle and not have to pay outside counsel or one of his own people than it is to go through the whole trial. And I think that's a more likely scenario. But I think if you've got these caps in place, it's just a motivation to go around this system and to file suit, as opposed to if you raise the caps or you don't have caps in place and let it be the immunity limits, then I think that it's more likely that somebody's going to use this system, which I think in the end is beneficial to the state as well as the plaintiffs.
Thank you. Representative Lynn?
Yeah, I with all due respect to Representative Walls and Representative Rogers, I really think that I feel strongly that the caps should stay in place and that they are set at an appropriate level. And I think one of the things that the Attorney General said that I think is really important to understand is this, and this has always been really my concern, and I think maybe some other members of the committee's concern from the beginning about this. I applaud the Attorney General for having set up this procedure and suggested it to us, and for us considering it, and I think we should obviously go forward with it. But this, as the Attorney General said, is a very plaintiffs-friendly system. If you were concerned about determining the absolute truth of whether somebody was sexually abused or physically abused, you would not go through this process. You would want, and I'm speaking for from the perspective of the Attorney General or a defendant in the case, you would want to have a fully litigated, fully discovered case because, candidly, I have no doubt that many of the people who are claimants were actually abused and should be compensated. But this system is plaintiffs friendly enough that there is, I would submit, a significantly greater risk that someone who has not been abused but knows that he can claim something or she can claim something that happened a long time ago where there are no records or very much incomplete records. There's nobody, perhaps the alleged assailant is dead or gone, can't be located, and it's very easy to claim I was abused and receive compensation. And so I think that is a real concern, but I think the Attorney General has concluded, and I agree with his assessment, that because there are a significant number of people who really have been abused and should be compensated, it's appropriate to have this very relaxed, plaintiffs-friendly system to do that. But what it seems to me that the cost that comes with that, or the trade-off for that, is there have got to be appropriate caps. And I think that these are very appropriate caps. And although I think the world of Davis and Onzo, I don't know current counsel really very well at all, but I think the world of Davis and Onzo, I've known him for years. He's an excellent attorney, and the plaintiffs are in great hands by being represented by him. But I have to say, candidly, I would be very surprised if there are a significant number of cases, assuming we pass this legislation, I would be very surprised if there are a significant number of cases that aren't adjudicated through this process as opposed to litigation. There may be some that are really bad, where there's a really strong case and people will go to, will opt to go to court. But that will be the exception rather than the rule.
Thank you. So I think I'm ready to call a straw vote. Representative Mooney, did you have something you wanted to add first?
I did just have a brief question, Mr. Chairman, for the Attorney General, if that would be in order. Just in terms of some background, through the years, have any victims filed suit and gone through the process you described with discovery and a jury trial and a settlement and a judgment?
You mean potential victims at YDC? Have they gone through the entire process and gotten a jury verdict? Not that I'm aware of. I'm aware of one. I'm aware of, off the top of my head, one, and I don't have the details, but one case regarding someone who was incarcerated, so not at YDC, where they went through an entire, they fully litigated their case. They got to a jury verdict. This was a physical abuse only claim, and the verdict was for $80,000. So that's just an example. But that's the only one that I can speak to. That's not to say there aren't others, but it's rare that someone would that a case like this would be fully litigated.
Thank you. That's helpful. Thank you, Mr. Chairman.
You're welcome. So at this point, I think we'll do a straw vote on item 7. Establishes the current statutory caps on recoveries. When I first ask, I'll ask if you support the language proposed. I'll be voting for the second, which is to vote opposed to establishing the statutory caps as proposed by the plaintiffs. So on the first vote, if you are in favor of the plaintiff's changes to the statutory caps, please raise your hand.
5.
If you're opposed to the changes, please raise your hand. So the vote is 8-5 for the working committee. All right, so let's do a time check. We've got a hard break at 5:30, and we're also wanting Ms. Ripple. Can you give us a status on whether or not OLS will have 103?
Yep, we have the amendment now.
Okay, so I'm probably going to end this about 5:20 so that Division 3 has 10 minutes to consider the amendment that OLS has. So I tell you that so that you can pace yourself and efficiently use your time. And if we have to go over because we're just not done, we've already said we're going to recess today anyways until Thursday at 2 p.m. So item 8.
So item 8 is another one for me. It's on line 31 on page 4. And this is pretty straightforward in what it provides. It basically, the sentence itself says, no claim shall be filed by an executor or administrator of a deceased former YDC resident. And presumably that's to make sure that claims by the family and the heirs of a victim don't have a right to go through this process. Currently, they would have that right to pursue action in a court of law. And then what we added was except by the surviving spouse of the resident. And frankly, I think that we added that back in for the fundamental reason that when you have somebody who has been married to a survivor, presumably that person has lived with the consequences of the abuse that was imposed on the survivor during their lifetime. And in this context, I don't know how this bill in this legislature should tell that spouse, that surviving spouse, that she's not worthy to go through this process and force her to go to a court of law.
So thank you. I just to speed this along a little bit. My thought on that is that the surviving spouse, when their spouse dies, they die with and the pain goes with them. The surviving spouse was not the direct recipient of the pain and anguish and the suffering. It was secondary, and so the pain largely dies with the one that was incarcerated and abused. The other is that with that individual dies the direct testimony and observation, and so everything gets to become secondhand and hearsay. I just think that just adds too much complexity, and I wouldn't be in favor of adding the surviving spouse. I know it's tragic to lose a spouse, but I don't know that this is the remedy for that. So is there any other commentary from anyone on that? Representative Wallner?
I just wondered what would happen if a claimant had started the process and died before the process was complete, and they were left a spouse and family. So how would that be handled?
I would say, based upon the way it's written now, it's measured at the time the claim is filed. So I would, the Attorney General might have a different opinion, but I would assume that claim could continue. But I do, yeah.
Thank you.
So Representative Weiler, go ahead.
I see room for problems here. A person who's not otherwise attractive, who's got an ongoing case, trying to get some woman to marry him. Hey, I've got stage 4 cancer. You marry me, you're in for a payoff at some point, whether I get this money or not. I'm just saying, it's not always an honest thing. We're not dealing with honest people. Thank you.
So I think Representative Wallner just raised a really good question that I hadn't thought of. What happens to the status of the claim if the person filing the claim dies before the administrator finishes the paperwork?
I think the way I've sort of envisioned it and the way I would read the statute is that once the claim is filed, the claim's been filed. So if someone passes away before it's been fully adjudicated, that doesn't destroy the claim. I mean, I think it may affect where the ultimate decision comes out, because it might affect what's available to both the administrator and perhaps the deceased counsel and the AG when it comes to verifying and getting the facts. So it could affect the ultimate value, but from my perspective, I think the cutoff is at the claim filing. And I think that gets to what I see as the primary concern, which is that without the victim having filed the claim, you don't have a direct statement from the victim. And these claims are hard enough to sort through and verify, given how old they are. Without having that direct statement from the victim, makes it difficult. But that same concern isn't there if a claim has been filed by the victim and they only pass away after the claim has been filed.
So my next question then for you is, do you think the language in the bill is clear on the status of the claim should the claimant die in the process?
It probably isn't clear enough. So if, to be honest, I hadn't thought about that coming in today, but it sounds like there may be room for clarification, which we'd be happy to work on some language for if it is the committee's desire that actually be the case. That's how I've read the language. assuming the committee is in agreement with that, I can certainly work on some language with Kevin to clarify that.
So Mr. Dean and Mr. Hatem, if we were to clarify the language as we've discussed here, would that meet your interests, or are you wanting to be able to will a claim to somebody after when there's no longer time for them to file their own claim?
So those changes would be helpful, and we would agree, we certainly think they go in the right direction, and particularly for clarification. However, we're not asking for the complete ability to will a claim. We're talking about a surviving spouse who may, in legal terms, inherit it by a will or under the laws of intestacy in the state of New Hampshire.
But you would limit that to only remuneration that would fall after the claim had already been filed by the living victim.
Right. I agree with that in concept, yes.
Okay, so I don't see any disagreement. It's just words that need to be written to clarify. So I think we'll forego a straw vote on that unless there's any opposition to just assuming. All right. Let's go to item 9. Reminds a victim of his or her rights at an earlier stage in the process.
Item 9 is page 7, lines 4 to 6. And this is, I think, an attempt to try to address the practicalities of a process. And, I believe this bill contemplates that, claimants may get a final offer from the Attorney General's designee and not respond for one reason or another. And I understand the practical side of that type of deemed acceptance, if you will. We put language in there that really is duplicated below that says, effectively, the administrator can assume that it's accepted, but it just needs to be clear that somewhere in the process, when they were notified of the award, they had fair notice of what their rights were under this process. And this is exactly the same language set forth below. Where is it? It's at line 23 or so. Where is it? No, it's not that. That's not where it is, but it's definitely the same language.
As I recall the conversation from this on last week, plaintiff's counsel accepted the idea that documenting it in writing may be going too far. That maybe a verbal kind of communication would be sufficient. This writes in that it be put in writing, and I'm just curious if you all shifted on that in the last few days, or if my memory's bad.
Really haven't, except we've added to the process. This presumes, I would think, a claimant who is not represented by counsel. You could certainly expect that counsel, if they were involved in the discussion, would make sure that there was a proper response to the settlement claims offer. This is for claimants who don't retain counsel, and to the extent there's a notice that says this is the final offer, we do think it's not necessary in the context of someone who's represented, but to the extent they're not represented, we see no harm in requiring notice at the time when the AG's given the final determination of what they're willing to settle on.
Okay, I'll ask it this way, because I'm having trouble reading the whole paragraph and contextualizing what you're saying with the words that are on the document. So I'm going to ask you if you think the writing is currently already clear that you've redlined to make this part of the law when the victim does not have counsel, and only then. is that correct? That you don't necessarily want this in writing for those that have no counsel?
So this revision assumes that the provision later on that says the administrator will provide this information at the time before, then what I'm saying here is that this notice should be given to the claimant at the time the AG provides their information. So if the legislature believes this notice is important, I think it should be provided before a claimant, in effect, does nothing and waives their rights to further pursue this claim, either by withdrawing it or asking the administrator to decide the claim.
So, Representative Weiler?
You don't spell it out, but you mentioned that it's for those that have no counsel.
That's right.
Perhaps that language should be included.
So, Mr. AG, does this red line from 4 to 6 on page 7 represent a material difference in what you view, how you viewed the process, or what you think is acceptable? If you don't have an answer on the spot, please just say so.
Yeah, so, I mean, so right before this paragraph, at the bottom of page 6, or if I'm looking at the same version you all are, but right before paragraph H, so it's G, I mean, the current draft does say within 30 days of receiving the investigation report, the AG must designate or indicate to the claimant and the administrator its updated position regarding the claim, and the administrator will advise the claimant regarding their options at that point. So
does that imply that this additional language is redundant?
It's redundant. I think I understand the concept. I think the concept makes sense. The one concern I have with putting it here, not to get too nitpicky, is that this confuses it a little bit. I mean, we're putting a deadline, I think, on the claimant to elect an option. So I think they've already been provided this notice. I don't know how many times they need to be provided the notice, but so it strikes me as unnecessary, but I also don't feel that strongly about it. That's I think it would be fine. But there may be a better way to do it that I just can't come up with off the top of my head.
If it's redundant and possibly conflicts or confuses, then we shouldn't do it. It's my view.
Yeah, I would suggest that maybe we work on some language to try to accomplish this without having it result in any confusion sort of further down the path during the process. Because what I wouldn't want to have happen is, I think it makes sense that there needs to be a deadline by which the claimant needs to indicate whether they're agreeing with the AG designee's position or not. And if that deadline passes, I just want to avoid a situation in which there's then an argument about whether they were ever provided notice of their options, or whether they were provided notice of their options every single time they had to be provided notice of their options, and result in a hang-up. So I think we can probably accomplish this by tweaking this language slightly.
Okay, so that tweak will appear in the working group's edits, and we'll be voting on it on Thursday. And if we can, we'll try to get it to the plaintiff's counsel as early as possible. If you slip them a draft before OLS finishes it, I wouldn't have a problem with that.
Okay.
Do you have any other comments on that?
I don't, and I think I'm sure we can figure out some language that works.
All right, good. So I think we're on your item 10.
Item 10. That's you.
Yes, that's me. And so this concerns, and this is at page 8 of our red line, line 6 to 12. And this concerns having some judicial review of this process. So, we agree with the Attorney General's finality concerns, And therefore, in our markup, we agree that there doesn't need to be appellate review. That said, we do believe there is a place for some limited judicial review of this process, this alternative dispute resolution process. And we do believe that our claimants should be entitled to get a judgment, a court judgment, at the end of this process if they believe that they need one. So we've cited to the RSA 542.8, which is the part of the arbitration statute, and achieving a confirmation and a judgment in a court following an arbitration. And I believe the Attorney General's version had previously referred to it as well, although striking out this review provision and also the appeal. So I think it's actually helpful if I just read to you, what we're asking the court to do here, which I think is pretty narrow, and especially we've narrowed it further in our red line here. So in an arbitration proceeding or in this proceeding, the court will only correct or modify the award for plain mistake, or will vacate an award for fraud, corruption, or misconduct by the parties or by the arbitrators, or on the ground that the arbitrators have exceeded their powers. Now, as I said, we've the one ground listed there, plain mistake, is the one that could be read broadly, and some courts have. So we've restricted it in our revision here to only mathematical errors. In other words, we're not asking a court to second guess what the administrator has done. We're just asking the court to ferret out corruption, fraud, misconduct, or obvious mathematical errors. And we think that form of limited review is justified and appropriate. And if a claimant wants to go and get a judgment, wants to get a court to review and get a judgment, they should be able to do that, just as they would in an arbitration proceeding.
So you're making reference to corruption and fraud, and I don't see those words on the document. So are those embedded in the RSA you've referenced?
Yeah, the RSA I just read to you, 542.8, provides the narrow grounds that a court will review an arbitrator's award, and those narrow grounds we have further narrowed in our draft here.
All right, Mr. Attorney General, do you have a comment for us?
Yeah, I mean, I understand the intent of this. I would have a concern with it. I'm not as concerned with the mistake piece, and I think that could be achieved perhaps by giving the opportunity to petition the administrator to take a second look if there's a thought that there might be a mistake. But the statute is it's a little bit broader than that. It gets into fraud, corruption, misconduct, but also on the ground that an arbitrator has exceeded their powers. I just think that opens up a number of potential arguments here, and really would give potentially the ability to argue to the court that the administrator has not applied the guidelines correctly and thus has exceeded their powers, and thus it, I think, potentially provides just another level of review for this in court, which I think the whole purpose of this is to avoid. And even if you file something in court just to try to correct a mistake, that requires, the Attorney General to look at it and potentially file something in response. I think it's unnecessary. I think it kind of goes against the purpose of this process. I understand the intent behind it, but I think if there's a concern for just plain mistakes or mathematical errors, I think that's better achieved by giving an opportunity to petition the administrator to take a second look than to open this up to court, which is what we tried to avoid.
May I address?
Yes.
So as far as exceeding powers, I think we could probably concede on that and make a further revision if that was a deal breaker. And I just want to also highlight, and I think David Vicinanzo has said this repeatedly, that we're dealing with trust with these plaintiffs. And I think having this limited, very narrow form of judicial review at the end of the process to make sure it's on the up and up and everything's been done right. And if they think it's necessary, they can get a court order and a judgment at the end of this process. I think they should be entitled to do that.
So Representative Weiler had his hand up first, and then Representative Umberger.
So this is a unique process. We're hoping it works. If it doesn't, we change it. But in the meantime, the whole purpose was to avoid court, to avoid cost in courts. If hundreds of cases go to the court for review, they're going to come back to us and say, you didn't give us enough money, because it's taken a lot of judiciary time to review these hundreds of cases. So this is a unique process. I'd rather let it see how it runs. If it's successful, if we seem to settle most of this stuff in a short period of time and don't have to drag most of them into court, then we've been successful. I don't want to drag this into court. So I am opposed.
Representative Umberger.
Yes. I don't think we can forget that the administrator is appointed by the Supreme Court. And so he's already the highest court official. And so so we're going to have someone down at a lower court level review a decision that is made by somebody in the Supreme Court area. So I just think that it's totally unnecessary. And I do agree with the Attorney General. If we want to add something in there that says, nobody's perfect, and the administrator might make a mistake on, math or whatever, then, I have no problem with that. But I think we all know that the guidelines, the monetary awards are all going to be out there for everybody to look at. And so, somebody could just, the administrator said ABC and equated to $1.2 million, and if someone goes back and adds it up and it actually is $1.4 million, then I think the administrator could change that without getting some kind of judgment from, I assume, the Superior Court. I would hate for that to have to go back to the Supreme Court.
All right, so I think we should probably straw vote this. The way I'd like to tee this up is I'd like to have the Attorney General and the working group take another look at this idea that there's some sort of an appeal process in here to where the administrator could be flagged to take a second look at what they did, just to make sure that we're not making mistakes that just get through the system. And keeping it out of the courts, I don't really have an opinion on it. But for the straw vote, I'd like to phrase it so that if you raise your hand, you're in favor of the working group coming back to this particular section and looking for a way to make sure that there is an appeals process adequate for the math mistakes that could be made. So if you raise your hand yes, then that's what they'll do. If you raise your hand no, we'll probably have a little more discussion. So if you're in favor, please raise your hand.
1, 2, 3, 4, 5, 6.
Maybe I didn't understand the question.
If you raise your hand, then you agree with me. No, I'm sorry. It's getting late. No, if you raise your hand, what you're saying is you want the Attorney General and the working group to take a look at this section of the bill, because the plaintiffs would like to have a judicial review, basically an appeals process put in there. And what the Attorney General has suggested is maybe there's a way to have the administrator come back and take a fresh look at the decision and the math and all to make a secondary confirmatory decision. And that we don't see that language right now because he's going to work on it. Yes, sir.
Without it going to court. Is that
Yeah,
right?
yes, my proposal, what I'm asking in the straw vote, if they should write this in a way in which we don't take it back to the judiciary. Because as Representative Ohnberger pointed out, this is essentially an agent of the Supreme Court. This should be a pretty capable, competent individual. So an appeal process to a lower court in some ways just doesn't seem to make sense. Yes, sir.
So one more question. So I assume the appeal process would be limited to a review of how it was done and the mathematics of it, right?
Right. So I've not read 542:8. So based on what I've heard here today, the other elements that maybe should be considered are things like fraud and corruption. But as I'm thinking about it, it makes no sense. If the administrator's the one that acted fraudulently or corruptly, they can't really review themselves in those situations anyways. I mean, a math error, anyone can make a math error. So I see that as being reviewable. So does that answer your question? I
guess I don't have a problem with the way we wrote the thing, with the amendment that we're working with, not the plaintiff's amendment. But I'm uncertain how to vote in that case. I guess I'm voting no.
I understand your concern. I respect your vote. The process I'm trying to follow here, Representative, is the plaintiffs. I think it's important to the entire process that the plaintiffs' counsel doesn't necessarily agree with everything the legislature's doing, but that we've been fair and they've been heard. And this is an area where it seems to me like maybe there's an element, they raise a good point. Is there a way for us to deal with it fairly so that they know that their opinion has been respected? That's where I'm coming from, and that's why I'm going to vote yes. But I respect whatever vote you exercise.
I very much appreciate the clarification. Thank you.
All right. So with that, let's take the straw vote on asking the working group to come back and take a look at the supplemental language that would create an appeals process back to the administrator for a second review based on math errors and the like. What's that, Representative Long?
I'm sorry, is it based on mass area? I think it's based on errors.
Yeah, it's technically written here, mathematical mistakes or miscalculations, and I think they can leverage the language. So with that, if you agree, raise your hand, please.
1, 2, 3, 4, 5, 6, 7, 8, 9.
If you're opposed, you'll raise your hand. 1, 2, 2. Okay. All right. Hopefully you can work with that. Okay. So with that, we're pretty much done. There were some we're done because we're out of time is the problem. We had
We're gonna go to 520.
I know, but is that 420? Oh my God. Oh, we got lots of time.
I don't know about the pace we're going.
No. We just finished up the plaintiff's piece of this, and thank you so much. I have a bad eye, so when I look that way, my peripheral vision was not good. Thank you, sir. Okay, so in caucus, we talked about, and if you're looking for an estimate how long this is going to take, this feels to me like it should just take another 20, 30 minutes at most. Okay. So in caucus, there was a discussion on FOSS and the FOSS exemption. I think we dealt with that earlier, so that one's done, right? Then there was something about whether or not the language on caps and having the caps put on the awards were reasonable, and then there was something about taking 25% out from the potential contingency fee. Do you want to talk us through that, Representative Lynn? Was that your issue?
It was, if I may, and I should note that Attorney Scullambrini and a representative of the New Hampshire Association for Justice are here. They raised this issue, and I had a discussion with both of them, but a pretty lengthy discussion with Attorney Scullambrini, who raised the issue, and I think Representative Emmerich, you had raised this issue last time at our hearing, that having the two-stage 25%, 33% cap on attorney's fees could arguably encourage an attorney to want to go to go through the administrative adjudication. I mean, having the administrator determine the case as opposed to settling earlier, simply for the purpose of getting a higher attorney's fee. I should just note that if it were able to be proved that an attorney actually did that, and that was the only reason for doing it, the attorney would be subject to discipline. I have no doubt about that. But proving that happened would be very, very difficult to do. So anyway, what Attorney Scullambrini suggested, and I think it makes sense, is to take out the two-stage process. So what I've proposed here is this is the second item down. It's number 14, Roman numeral 14, and it reads. It would change the existing bill to read as follows: the administrator may approve.
I want to call a timeout there. Okay, so using the Umberger Amendment 0891, what page and what line item are you wanting us to jump into?
Yes, I'm sorry. Thank you. It is on
Page 8, line 27.
8, line 27. Right. Yes, line 27. So that, which is Roman numeral 14, and so that paragraph would be removed, and substituted would be the following: the administrator may approve all fees and costs of the attorneys who represent claimants in proceedings before the administrator. The administrator shall not approve any request for attorney's fees or cost. There's a typo there, but for attorney's fees or costs which are not reasonable. The administrator shall not approve an attorney's fee in excess of 33 1/3% of the amount of the award. All costs and attorney's fees paid to the claimant's attorney shall be paid from the amount awarded to the claimant. That sort of takes out. There's only one cap on fees. It's 33 1/3%. That doesn't mean the administrator has to award that. The administrator can award a lower amount if that's the reasonable amount. But 33 1/3 is the cap, whether the case resolves early or following a full adjudication. And I think Attorney Scullambrini's point on this, and I think it's well taken, is very often the reason that a case will resolve early is the attorney for the claimant has put in a lot of work to put the case together and to convince the Attorney General that the case is worth settling early. And the claimant and the attorney representing the claimant shouldn't be penalized if they've done that work. So I think that's I think I've accurately summarized what Attorney Scullambrini would say.
So let's go ahead and get you on record. Why don't you come up and use the microphone here and introduce yourself and just state what your position is relative to what Representative Lynn just said.
Mr. Chairman, my name is Anthony Scullambrini. I'm here on behalf of NHAJ. The last name?
I hope.
Oh, man. If you thought Vicinanzo was bad. Scullimbrene is my last name. I work out of a small firm. It's me and a former prosecutor, Leslie Gill. We run Gill and Scullambrini in Nashua. I've practiced in New Hampshire for a long time, and I've done cases involving kids that have been abused. I've also actually practiced at the public defender where I represented kids that were in the process of being abused while being held at YDC. So I've had a different perspective than the other people that have testified in front of you. Representative Lynn accurately summarized my position, and I think that the reason why this is the better way to go is because in looking at how similar mass torts have been handled in other jurisdictions, specifically in federal court, there is a process by which the plaintiff's counsel submits a request for a fee, for example, in a class action, and then the judge evaluates the merits of the fee. And in doing that, they've generated case law on this point. And one of the things that the case law says over and over again is that there is a value to the plaintiffs in having an expeditious resolution. And I can think from my own personal examples, the number of cases that I've had involving similar situations to this that resolved pre-suit are all of them. When I take a case like this, it represents a significant risk to me personally. I can tell you that cases that we've had that are similar to cases like these require an enormous amount of expense on the front end on our part. We're putting our money that could otherwise be sent home to get a new car or something else. We're putting that money on the table because it's a contingency fee. We won't get that money back unless we collect for the injured party. And so that gives attorneys in the system a real incentive to take meritorious cases. And that's not to say that all the cases are meritorious or that all the attorneys take meritorious cases, but the idea that you would disincentivize working things up ahead of time and encourage people to go to this hearings process sort of cuts against the purpose of the bill. The purpose of the bill is to make a victim-centered, expeditious process to resolve these claims. And I think that good attorneys, and this is going to sound corny, but my experience in New Hampshire is that most of the attorneys are good attorneys, will recognize the value to their clients, to whom they have an ethical obligation, to resolve these claims as soon as possible. And so if you create this unusual incentive to stretch it out, my fear is that incentive could be abused, or that incentive could be something that becomes systemically disruptive to the process.
So thank you for that, and maybe you're not the right one to ask this, but I'll ask anyways. Doesn't giving the administrator the discretion to approve attorneys' fees up to 33 1/3%, doesn't that also create an odd incentive for the administrator to basically rubber stamp 33 1/3 for every case?
I think that that's something that is really governed by the norms of practice for civil plaintiff cases, and oftentimes that is the number that's set. I know that there are places where they vary. For example, in this state, if you're representing somebody under the age of 18, the statute provides a cap of 25%. And I point out that statute has been in effect for a long time, and it provides less incentive for cases involving kids to come forward, which is in part why this problem has taken so long to get addressed. So I think that the incentive issue is something that we can deal with, that we've dealt with before, but there are cases that go against the norm in civil practice and ask for higher amounts on a contingency fee, such as medical malpractice cases, in some places slip and fall cases, where they'll have a variance from the norm of 33 1/3%. But I think that as the limit is fundamentally fair and reasonable, because that's what's being done out in the marketplace right now.
So I understand that, but the part of this that maybe you could help me with is early on in the process, when the victim shows up to talk to an attorney and they start talking through the case and start talking through the implications of how much money could be received, I would think early on the attorney would want to point out what their contingency fee would be. If it's a variable rate like this, where you don't know until the end of it, how would the attorney give the information early enough so that the victim knows what they're dealing with?
This is an issue that's dealt with all the time by lawyers that represent plaintiffs in class actions. And I believe the way that it's normally done is that you explain to them that the cap is this much, and you could get up to that much as your fee, but it's possible that the administrator could ask for less, and that the statute controls the fee by giving discretion to the administrator. I mean, it's the same thing when you represent somebody in a criminal case. You don't know what their sentence is going to be. You don't know whether the jury is going to find them guilty or not. And we still deal with that uncertainty all the time. So I don't think it's necessarily an unworkable system to have it be left to the administrator, because it happens all the time in mass tort cases in federal court every day.
So, Mr. Attorney General, do you have the language that's been proposed? And there's just one typo in there that Representative Lynn pointed out, but
Yes.
do you have any comment? Do you think this improves the bill that we have, or not?
Yeah, I mean, I would agree with Attorney Scalabrini and Representative Lynn regarding, I think the point was well taken regarding the incentives, and we had talked about that, I think, at a previous hearing, that, to have a potential higher cap on attorney's fees if you take a claim through the resolution process could potentially provide a perverse incentive to drag the case out. I do think in reality, an attorney is governed by their ethical obligations, and if it's better for their client to settle earlier, I think the vast majority of attorneys, we wouldn't have to worry that they just drag a case out in order to get higher attorney's fees. But I think that incentive point was well taken. I also agree that that we certainly wouldn't want to disincentivize good work up front to avoid having to go through a resolution process. I would also agree with Attorney Scalabrini on the concern that that having a sort of that there would be uncertainty with a cap like this. I think I agree. It's not that uncommon for an attorney and a client in certain kinds of cases, especially mass tort cases or other types of cases, to have a negotiation regarding what the attorney's contingency fee is going to be, and then get to the end of the case and you still have to go and get your award of attorney's fee, or your attorney fee number, confirmed by the court. In this case, it'd be the administrator. And so it's not that uncommon to have some level of uncertainty there. But I think what the client will know when they negotiate with their attorney is they'll know that it's not going to be any higher than what's in their agreement. And my sense is that if this number is in the bill, any client who's going to go through this, or any claimant is going to go through this process, they'll probably have that discussion with their attorney. They will know that the number is, the highest potential number is going to be 33.33%. So all that to say, that was another long answer, but I generally think this is an improvement, and I'm in general agreement with Attorney Scalabrini's comments.
Thank you. Are there any other comments from the committee members? All right. So I'm not sensing any opposition to this. So without anyone stopping me, I'm just going to ask the working group to adopt this language as replacement language, and just do it substantially in the same way, fix a typo or two, but I think we're okay with this direction. Anyone disagree? Nope. All right. So thank you. We're getting ready to talk about right to know. Is that your topic, or do you want to go back to the cheap seats?
My goal is to make this as easy and as quick as possible for you guys.
So, Mr. Chair, for the record, my name is Marissa Chase, Marissachase. I'm the Executive Director for the New Hampshire Association for Justice. I bring Tony to as many legislative hearings as I can because he's succinct, distinct, and has a lot of real-world professional and personal experience across all areas of criminal and civil law. So, certainly if there are others in the room that are more, focused on the right to know issues, would gladly, switch places with them. But I also trust Tony's legal brain to provide any insight that might be helpful on this piece or any other piece of the bill.
Thank you. Do we have any language on substitute for right?
I do, and this would be on page 9. I'm sorry, in Roman numeral 13.
Yeah, but there's an error in
Oh, should it?
14 and 16
Oh, right, no, you're right.
doesn't go along.
14, it should be right. It should be 16. On page 9, where it says Roman numeral in amendment 0891, yeah, line 8, it should be 16, but it's on line 8, page 9. So what I would propose is to.
So just so the clerk can keep up, we're talking about page 9, starting at line 8, probably running through line 12. Is that correct?
That's correct, yes.
Which position on the page?
Oh,
It's,
that's
it's the third, it's the last one down.
Okay.
The last one down. So it should, as I say, there's a typo there. It should be section 16. But anyway, the way it will read, the new language would be, records of the Youth Development Center Claims Administration and the YDC Settlement Fund pursuant to RSA 21M 11 dash, should be a small a, not a capital A, but dash A, with the exception of settlement agreements which shall remain subject to RSA 91A:4 Roman numeral 6, and, comma, after a claim has been finally resolved, such other records, the release of which would not constitute a violation of other provisions of law or an unwarranted invasion of a claimant's privacy. So this, and I think what this is designed to do is, in my view anyway, to provide the maximum amount of public disclosure after a case has been settled, the maximum amount of public disclosure as would be allowable under law, and balancing, against the claimant's right to privacy. So I would assume, for example, that absent really extraordinary circumstances, a claimant's name would be redacted, would not be released to the public.
So if I were to talk to a layman constituent, I would explain this, and tell me if this is a good explanation or not. That what we're trying to do is conform as closely as we can to the 91A provisions for public disclosure, but that we recognize that these cases occurred when the victim was a juvenile, and that there are, because it's such a sensitive area and because they were a juvenile, we have to make sure that their privacy rights are also protected. But we are trying to respect 91A. Would that be accurate?
No, that's exactly accurate. So, for example, as you say, because there's another, that's why the others reference to other provisions of law, because under the juvenile laws, RSA 169B, the records of the juvenile case are sealed pursuant to statute. Those are not available pursuant to statute. But there may, presumably, in a case, that has been resolved, there may be other records that would not be subject to that restriction, and that would be, if not prohibited by some other provision of law, and if it doesn't constitute an unwarranted invasion of privacy, then those records could be disclosed. So I think the way you described it is accurate.
Thank you. So, Ms. Chase, it looked like you wanted to say something? Oh, okay.
One thing that I want the committee to be aware of is that because there are two different sides to the coin here, that there is the civil process with this settlement bill proposed, there is also a criminal side to this, and the Attorney General is prosecuting a bunch of the people involved. To the extent that the information is relevant to the criminal case, then it would be floodgates are completely open. The case law from the Supreme Court in the United States and here in New Hampshire is pretty strong in terms of disclosing information. The main case on point from the U.S. Supreme Court involved a juvenile in a juvenile case in Alaska. So there is precedent for the idea that whatever happens here, even if there is some attempt to protect it, it's not going to stay protected, especially if it somehow has any impact on the criminal case. So I just want the committee to be aware of that in terms of the limitations of confidentiality.
So have you seen the language as drafted by Representative Lynn? Have you looked at that?
Yes, and I think that that language is exactly right. I think that the thing that I was pointing out was other provisions of law could also include constitutional discovery obligations pursuant to the criminal case. So, but I'm sure Judge Lynn knew that, so.
Yeah.
I'll remind him later about the constitutional issue.
I do-
So,
yeah, excuse-
Mr. Attorney General, I assume you also have this language in front of you? And what are
Yes.
your comments?
Yeah, I think it's a point well taken that there could be information that is relevant to a criminal case and would have to be turned over to the defense. I do think that still would provide some greater level of control than making it subject to 91A. So that's right, not the same as just say the Concord Monitor asking for the records and getting them within 5 days. You know, we may have to turn it over to the defense. It may get into the public realm because of that eventually, but it would be a more controlled, at least orderly process. I'd also we should keep in mind that there will be a lot of folks who come through this process for who we never could have charged their cases because past the statute of limitations, or we couldn't put together enough of a case to bring charges. So while there will be some whose records might be relevant to a criminal case, there will be many whose records will not be related to a criminal case. So, but we will keep that in mind, and that is a factor the committee should be aware of.
So this language, as proposed by Representative Lynn, yes or no? You can live with this or not?
Oh, yes. Yeah, Representative Lynn and I had talked about it, so
All
yes.
right. No, I just wanted to make
For the
it-
record, yes.
Okay. And then Representative Umberger, did you have something?
I just wanted to agree that we all recognize that some of these claimants may in fact end up on the criminal side. You know, not them themselves, but their records.
Oh, right, yeah.
Yeah, could end up over on the criminal side. And that's it.
So do you have another comment? It looked like you might,
Oh,
Representative
no,
Lynn.
no. I was just, I thought you were gonna, you
No,
were ready to go on to the
So
last one.
I'm not sensing any opposition. Is there any opposition to accepting this language as a substitute for the public transparency part of the bill? No. I'm not seeing any. So, Representative Wallner, I don't want to assume. Okay, so let's do that. Let's have the working group include that. The next thing up, we're getting really close to being done. There was an issue related to the ownership of the development of the guidelines, and you know who ultimately would how we would coordinate them, how we would approve them, and how they would be forwarded to the Joint Fiscal Committee. Representative Lynn, did you have any language on that part?
I
just,
did, and this is what we had discussed this a little bit earlier with regard to the plaintiff's proposed language, and as I mentioned then, I think that although the Attorney General ought to get input, you know, and give very serious consideration to what the claimant's counsel has to say with respect to the guidelines, it should be the Attorney General that has the ultimate authority to develop and present the guidelines to the Joint Fiscal Committee and the claims process. And so the change to Section 4 that
Could you do page number and line number, please?
Oh, yes, sure. It's page 3 of the of Amendment 891H on line beginning on line 11 and running to line 24, and most of the change is really in the first line, really, or the first two lines. So this would say Section 4A, as soon as practical following the effective date of this section, the Attorney General, with input from claimant's counsel, shall develop and present to the Joint Fiscal Committee a claims process consistent with this section, including the development of claim forms, identification of necessary or helpful documentation, and guidelines for valuing claims for settlement purposes, which take into account consideration of, it should be of, the following factors. And then from there on, the factors are the same as appear in in sections 1 through 4 of the amendment, of the previous amendment.
So as I understand what you're doing with this proposal is on line 11 and line 12, it says that the claimant's counsel and the attorney general, including the advocates, shall develop and present. And what you're doing is you're clarifying that the attorney general is ultimately responsible for what gets submitted to the joint fiscal committee, and that receipt of all the appropriate input should be a prerequisite to that. So we're modifying kind of who owns this process.
Exactly. It's really, I mean, subject to the fiscal committee ultimately, but it's the attorney general that makes the decision.
The recommendation.
Recommendation, yes.
Representative Umberger.
Yeah, I certainly don't want to leave out the victim witness advocates in here, because I think they play a very vital role, and so I'd like to have them back into this statement.
Did Representative Lynn's language delete the advocates?
No, it did.
It did.
But you're right. I don't disagree with that at all. I think you're right.
All right. Representative Wallner?
Thank you. I'm really concerned about the fiscal committee part of this, having spent a couple of years on the fiscal committee over the years. I'm not sure that the expertise is there to really make sound decisions about this. But also, as I read this, and Judge Lynn can help me read it more carefully, it says that they shall be developed and presented to the fiscal committee. But it doesn't say anything about the approval of the fiscal committee. So is this just to let us know what they are? I would feel differently about it if that's what it was, is just information to the fiscal committee.
No, I think I mean, you raise a very good point, which would, I mean, the language should, I envisioned that this would require approval by the fiscal committee. But you raise a good point. If the language doesn't say that, and that needs to be
I think it
changed.
says down on line 20.
That's further down.
Oh,
Yeah.
Is it further down?
Yeah, it's further
Sorry
down.
about that. I was just reading.
Oh, all right. I'm sorry.
Yeah.
I was
Yes,
just
yeah,
reading
I'm
the
sorry.
part
Right.
that was
You're
just
right.
handed out. Okay.
Representative did you have a follow-up, or you?
No,
Wait a second. Representative Wallner, are you done?
Well, I just am concerned about the fiscal committee being, I mean, a lot of the people in this room have served on the fiscal committee, or at least watched it in action. And often there can be a lot of delays. Things get tabled. They don't come off the table for several meetings. I'm really concerned about the fiscal committee ending up with the final decision here when the experts in this field have put together the process. And those are my concerns.
Representative Umberger?
Yeah, Representative Wallner, I'm like, I agree, okay? But what we were, I think, looking for was some sort of legislative review. And I didn't want to have it have to go to a Senate committee and a House committee and get voted on or whatever. So if there's some other joint committee that you think would be better, I'll be more than happy to give it to them. They may not want it. That's my point. But I was simply looking for a way that we had both sides of the House to be able to take a look at it and because they are going to be reporting back to the fiscal committee on how they're spending the money, what the claims are, you know, how many sexual abuse, how many physical abuse, and that'll be coming every quarter. So I just felt that it was a better place than many. Even though I'm in full agreement that if somebody else wants to take it, let me know.
So as I remember, the primary principle we were after was that there should just be some legislative input or inclusion, because we represent the representatives of the people, and this entire program is going to spend the people's money, and that there should be some transparency in the process. So to me, this seemed to make sense as a way to ensure public involvement, because it's such a big deal.
Okay. So I guess the other question I would have, and I'm sorry I wasn't on the right, I was just reading off the piece of paper that was handed to us. I guess I would wonder about whether it's looking for a up or down from the fiscal committee, an approval or a non-approval, or other things that happen at fiscal, or is fiscal going to be able to in some way modify what's presented to us?
Well, I don't think that's been written down. My belief, as I've listened to this and thought about this, is that the Joint Fiscal Committee would take an up or down vote, just like we do on every proposal presented by the executive branch. And we don't have the authority to do any direct modifications. If we, for some reason, we wanted to table or vote no, that would be a signal to the Attorney General and to the public to take another look at what they've presented us. And I don't imagine that scenario playing out, but I do think the legislation should anticipate, you know, how we would handle that. I would be in favor of a yes or a no, as opposed to making this an item of information. But that's just my position.
If I could, if you look down at line 29, it does say, if the Joint Fiscal Committee votes to object to the proposed claims process and guidelines, the Fiscal Committee shall articulate its reasons for objections in writing, and the Claimants Council and the Attorney General shall present approval for approval of a revised version. So, I mean, it basically says that the Fiscal Committee can reject it. I can't imagine why, but it can be rejected. I mean, I don't care. I just didn't want it to get bogged down some other place, is what I'm concerned about.
Representative Wallen, do you? No, okay. And so the Joint Fiscal Committee at least is logical in the sense that it's efficient, because it has the Senate and the House both participating, and it does have a financial implication. Although the details are legal and beyond us, I agree with that point.
I do have one.
Representative Hatch?
Yeah, thank you, Mr. Chair. I'm just thinking, we've given a lot of authority on the front end of all this, and a lot of control within the Attorney General, and I'm sure, appropriately so. And so it goes to the Fiscal Committee, and as Representative Wallner pointed out, there's a lot of things that can happen there, and not all of them necessarily to add to the flow of what we're trying to accomplish here. So why would it be out of order, I guess, in the context of it goes to the Fiscal Committee, they can have a vote, and in case of a negative vote, is there a mechanism for the actors that had made the settlement to go forward if that negative vote is not within a certain period of time or not clear enough? And I haven't had time to think of this through so much, but in terms of JELCAR, Joint Legislative Committee, a department can go forward with some of their rules, even though, under the objection of Gelcar, and there is a mechanism for that to be clawed back. I mean, I don't know, maybe I'm complicating things, but.
No, it's all good thought. It seems to me like it wouldn't take long to get this on the fiscal committee's calendar because the fiscal committee meets so regularly. So I don't imagine a big delay in terms of having the settlements take place without an approved set of guidelines. I think that would defeat the purpose of the review. I mean, assuming that the Joint Fiscal Committee is competent and is actually truly a representative of the public, then it's okay to me if the public's representative says, time out, we've got an issue with this. I don't imagine that happening, but it could, but I don't think that scenario is necessarily a bad one. Do you have a comment to that? Because it looks like you're thinking there. You got your thinking mask on.
I am, and along with what the Attorney General wanted to accomplish initially is he wanted separation or somebody wanted to be assured that the complainants understand that this is not a state per se oversight and the system isn't rigged against them, so to speak. And if you're bringing it back around to that same body, I don't know what the look is, but I'll have to think on it. I'm sorry.
No, I think that's a fair thought. It's a good thought because you're trying to make sure that people have confidence in the system. But I imagine these guidelines need to be developed before we unleash the settlement process on the public. And so there won't be an issue, I don't think, and I'll let the Attorney General correct me. I don't think there will be an issue of getting people all ginned up to start working the process until after the guidelines have been approved anyways.
Yeah, I would agree with that because I think claimants are going to want to see what the guidelines look like before they decide to even embark on the process. So, not that they won't want to see us move quickly, which we will do, but I would agree that there would not be a push to kind of move forward without guidelines.
Okay, so because we still have plaintiffs' counsel in the room, what we've done, if we go forward with this, is all we've done is we've shifted the co-responsibility between the public and the attorneys general before this goes to joint committee. We've changed that from being like co-equal to making sure that there's sort of a unity of command principle in place here, that there's actually somebody accountable for delivering something to the fiscal committee. When everyone's responsible, nobody's responsible. So this clarifies responsibility. Do you have concerns about that? Yes.
So the one thing that I would point out is that this is an unusual legal creature. Most of the cases that involve mass tort litigation are agreements between the parties, and usually it occurs after what are called bellwether trials. So for example, I had a case with my client had a vaginal mesh issue. There was a multi-district litigation going on in the vaginal mesh cases, and they had bellwether trials, and it was the leverage that was granted to the plaintiffs' parties that helped them craft what are called the damage matrix. This is what we're talking about. So this is the entire thing. If this does not work for the plaintiffs, then the system won't work. And so one thing that I had thought of in listening to the debate here is that without some obligation that the plaintiffs' counsel and the attorney general are in agreement, then there's a real threat to the entire bill as a system of resolving these claims. And again, it goes back to the fact that this is a statutory beast as opposed to the settlement of multiple claims after a trial in court. The leverage that's there to get the parties to negotiate at somewhat equal grounds is gone because of the way that either Representative Lynn's amendment or the bill itself as it's currently proposed, the leverage is not there to make sure or to help incentivize the two sides to come together. So, for example, if instead of
In
this,
Representative Lynn's language.
yeah, instead of in Representative Lynn's language, as soon as practical, the following effective date of this section, the Attorney General, and strike out with input from, in agreement with the claimant's counsel. I think that means that the statute would create some of the leverage that exists in these multi-district litigation cases out in the non-statutory universe. Otherwise, there is this is the damage matrix, be clear, is the whole thing. If the damage matrix is not done correctly, then the incentive process or the incentive of the entire settlement bill falls away.
Mr. Chair, if I may, I usually do this to myself, with myself, in my own brain every time after I talk to Tony. What Tony's referencing, just to be clear, I have to dumb it down for myself. The guidelines is the damage matrix. And while this is not a new phenomenon, like mass torts, multi-district litigation, these mass tort settlement funds happen all over the country in all different kinds of contexts. In our research, we were only able to find one statutorily instituted compensation fund, and that was the 9/11 Victims Compensation Fund, which was an act of Congress. That was on the federal level, so no state has done this before. I just wanted to give that context to all the other stuff Tony said.
I appreciate what Attorney Scullambrini and counsel for the Association for Justice have said, but I do think that that the Attorney General should retain this authority to make the final decision to us, because the attorney, presumably the Attorney General has not gone through all this process to come up with a matrix of guidelines that are going to be, are not going to be receptive to claimant's counsel. There would be no reason for him to do that. It would just be forcing people to go into court. And so I don't see that happening. I do see, however, if the requirement is agreement, then you're going to be back to that situation of needing to have another administrator or another adjudicator to just because if they don't agree. So I just think it's much better to leave this in the hands of the Attorney General. He's a public figure. I think we can rely on him doing a good job that's fair to both sides.
I appreciate those comments. Mr. Dean, Mr. Hayden, did you want to chime in on this? Because I'm getting ready to do a straw vote. I just want to make sure you're heard.
Thank you all.
Don't go away. We might have more.
I would just like to add, I think the last subcommittee meeting, there was a discussion by Dave Vicinanzo, who's actually been through this process a number of times on the defense side. And, what Dave says this time and time again is this whole determination of the guidelines is it's a brutal process, because both sides really need to confront very difficult facts and circumstances and try to work through them. I would say, I offered that mediator earlier as a way of sort of helping the Attorney General and us get through the process if it was needed. And I would say if this amendment is used, you're really taking out you're turning it into a one-sided process. And I don't see how this will help the process of getting to a claims guidelines at all. So,
Mr. Dean, do you want to add or amplify or argue? Maybe you could disagree with him.
No, I agree with him, and I agree with the comments previously as well. I think it's been a common theme we've said throughout, and Dave has said many times that this is all about trust, and this would clearly be a difficult hurdle for us in talking to our clients and giving them trust in going into the system. You know, I feel like if they know their counsel are getting a seat at the table that's co-equal with the Attorney General in hashing out guidelines that they think will be fair, that'll go a long way.
Representative Umberger.
Thank you. I certainly hear where you're coming from. What we have written right now is I think we give the Attorney General 6 months to come up with the guidelines. Wasn't that the criteria? I think it was someplace along in there.
Yeah, I think it's as soon as practical in the first instance, but there's an overall deadline of December 1 by which that notice has to get published. So
right,
it probably ends up roughly being 6 months to get everything done.
Yeah, because this is goes into effect on passage. So when do you throw up your hands and say, I can't agree? Since we have the 1 December deadline to notify people. You know, do you do it on the 29th of November? Or, you know, if we are in agreement on 90% of the stuff, is that not okay? You know, it's just like as we have gone through the legislation, you know, the group has accepted a lot of your language. The AG's accepted a lot of the language that Dave provided. So I think you know or think you understand that we are willing to compromise, but I need to know, you know, how do we get to the 6 months? How do we get to the 6 months if we don't have one person in charge, one agency in charge? That's where my concern is, because I'm telling you, I'm not going to give the AG any slack on this, which means I wouldn't give you any slack either. But that's the date. And I think that all of us are passionate about getting this going. But if you don't like an and or an or, and, you know, and that becomes your issue, you know, then how do we move forward with the deadline? And I don't, you know, I'm just using that as an example.
Is that a question or a rhetorical question?
Well, I guess it's a question, you know.
Okay.
Because
Do you care to respond?
Well, to go back to what Jim said, I mean, I think the answer is we negotiate, and that's why we like the idea of a mediator. And it doesn't have to be the administrator; it could be someone completely different. You can set a date for a mediation. You know, we can negotiate ahead of that mediation to get 90% of the issues done, and then we've got that last nugget. And I mean, you know, I'm sure the Attorney General's been to many mediations. You know, there's a lot of incentive to get it done on that day.
Follow up?
Yes, follow up. I guess I would prefer not to put that in the legislation, because that gives you an incentive not to agree, because you know that mediation is going to occur. However, if the AG and you at some point in time are knocking heads, he has the authority to do what he needs to do to make sure that he meets that deadline. So I would prefer that we just leave it out.
So I can't get out of my military mindset on this. Is that as a legislature responsible for crafting this, we have to worry about accountability. And we can hold the Attorney General accountable for delivery of the results. We cannot hold the public accountable for delivery of the results. So as an agent of the state, the Attorney General has all the incentives that he could have, I think, to make the guidelines fair, agreeable, acceptable, but at the end of the day, somebody's going to have to decide what are we going to do. And as a member of the public, if it comes to the Joint Fiscal Committee, you still have recourse. So it isn't like the Attorney General can make a decision without it being subject to legislative review anyway. So I'd like to call a straw vote. I'm going to vote in favor of Representative Lynn's language around this. You can make some minor modifications to make sure the language works and everything, but so what I'd like to do with the straw vote is, if you're in favor of Representative Lynn's language substantially as written on this extra handout, then you will raise your hand, and if you're opposed, you'll raise your hand on the second vote, and if the second vote prevails, we'll discuss it further. So all those in favor of accepting the Lynn proposal and to ask the working group to come back with their language in the bill, please raise your hand.
1, 2, 3, 4, 5, 6, 7, 7.
Those opposed, raise your hand. I think 3. We got
Sorry, 3.
It's just hard to see because the chairs are in the way. Okay, so 7 to 3, we'll do that. Okay, then the next item I had was making sure that, thank you, making sure there's a sunset date so that the law can self-close, and I guess the working group's going to do that because it's got to be in the OLS version.
Yes.
And then I wrote a note, something about retired judge language. There was something about if you selected a retired judge, then the retirement issue, do we need to write language on that?
Yes. Yes, and Mike and Kevin have that already.
Okay,
They're
so
gonna take care of it.
So with that, I think we've force marched through all the items that we had for today. Are there any last calls by anyone out in the audience? Any last calls by the committee? Okay, so I'm recessing this, right? Okay, so with that, we're going to recess the hearing on HB 1677, and we will reconvene Thursday, March 3rd at 2 p.m., probably in this room. Okay, if you're on Division 3, stick around because we're still going to talk about HB 103. Mr. Ripple, did you hand out the OLS change document? All right. Okay, I'm going to call the hearing on HB 103 back into order. The reason we're doing this is because we had OLS turn around for us very rapidly an amendment that you should have 2022-0904 hotel. Does everyone have that version? Okay. In this version, we added a sentence that shows up on line 8 at the end. That sentence runs through line 10. It reads, in addition, the general court recognizes that personal responsibility is an essential component of any strategy to improve individual oral health. It didn't seem like there was any objection prior. If there is, please speak up. Then I think we go down to line it's in that area between lines 19 and 22 on the first page. And what did we add here, Mr. Ripple? It looks like we added fostering individual behaviors that promote good oral health.
Yes, yep, on line 21.
On line 21. Was that the only change in the sentence?
Yes, it was.
I think it is. Okay. Then, again, if speak up if you have any opposition to this. So then we go down to line.
So I can, if you'd like, I can point these out.
28. Go ahead. Walk us through.
On line 29, you've added patient education to the list of the state's requirements.
Right.
And then the same on page 2, line 6.
Okay, and so that just made sure that the framework included those concepts because we already had it embedded in the details of the contract where we said that they needed to receive education for behavior management and smoking cessation counseling. So there wasn't a substantive change. It was just making sure that it was more clear that personal responsibility matters. Is there any discussion on those changes? No? Okay. So what I would like to do is to, do we need to take a roll on this since we're going to recommend to the full Finance Committee a position on this bill?
Yes.
Yes. Okay, so I would entertain a motion to accept Amendment 0904 Hotel.
So moved.
Second? Second by Representative Wallner.
Okay, motion is amendment.
0904H. 2022, sorry, Ken, at the beginning.
This is 3/1/22. The bill is HB 103. And
So is there any discussion before the vote? Seeing none, would the clerk take a roll?
Yes.
Yes.
Chairman Edwards,
Yes.
6-0.
All right. Okay, so it passes. Thank you so much for sticking around. Dr. Finney, did you stick around just to hear a 6-0 vote? Yes, and just to make sure there was... That I didn't screw it up at the end? All right, so with that, the hearing on HB 103 FN is closed.